Hello, everyone, and welcome to Legalbytes. My name is Alita. If you're new here, my name is Alita, and I'm a lawyer. I'm licensed in California and DC. And on this channel, we explain the law one bite at a time. And usually about once a week, I do a live stream where I invite some of my best legal mind friends to come and talk about various issues that are going on. And obviously, the biggest topics lately have been the Kyle Rittenhouse trial and the Ahmaud Arbery trial. So welcome back, Nate the lawyer, and welcome back, Penn Civil Law. And for the first time ever, Runkle of the Bailey. Ian, welcome.
Thank you. It's good to be here.
Yeah. So I know that obviously for the past week, we've all been sort of chumming it up on Nick Recada's channel. And so if people are coming here from there, they probably recognize all of us. But Ian, for anyone that doesn't know you yet, why don't you introduce yourself a little bit?
Sorry, I'm Ian Runkle. I'm a Canadian criminal defense lawyer, so I'm north of the border. I do a lot of firearm law, and real big interest in self-defense stuff. I've really been enjoying actually watching the distinctions and the similarities in terms of what's been going on in these trials between the Canadian rules and the US rules. And in fact, we just had a big Supreme Court decision on self-defense. That's the Cahill trial. So things here have changed a little bit recently. So all of this is fascinating, and we may actually, because Canada tends to look to the US as sort of its big brother in a lot of ways, we may actually see some additional legislative changes pushed up here just because these trials are controversial, and that tends to be how Canada rolls. We get panicky about things.
Nice. Well, welcome. We're so happy to have you here. And I know that people in Nick's chat, I think, have also enjoyed having you on there. So I did see, actually, we probably should start referring to you as I've seen on Twitter and elsewhere, people have started calling you Logolus.
The haircuts started because basically they had all the barber shops and so forth shut down. And then I just kept it going, in part because there's one person in my comments who's just super mad about it. So I was just like, you know what, I'll just keep going. But I do have a fundraiser going for the local children's hospital. It's still running. It was Extra Life. So I did a 24-hour gaming stream on the 6th. But it's still technically running to the 31st of December. And I did pledge that if it hits 2,500, I'd shave my head. So if it really annoys you, that's still an option.
Get him to 2,500 now. Look at all that beautiful hair. You know, you should donate there because you have a lot. You could donate it, right, to like a charity or something.
It might be long enough, yeah.
Yeah, I'll certainly ask and see if it is long enough, because if it is, I mean, why waste it?
Yeah, I think so. I've donated hair before, so it's been like, usually if you've got at least like 10 inches in the cut, then I think that usually is enough. But I think it also depends on where you're donating it to also. So because some places are pickier than others.
I have to say this 24-hour gaming stream has given me an idea. I think we should all buy Call of Duty in honor of Kyle, and I think we should have a panel. We should have a panel of Call of Duty. I have to say I haven't played anything like that in a long time, but we'll do it in honor of Kyle. And maybe we can get a Kenosha map or something for the game. It'll be even better.
Oh no, I can see that turning very inappropriate too quickly.
Yeah. I was surprised nobody's called Kyle the Kenosha Kid. Like I was putting up a Kenosha Kid trial, but then people were like, "No, that's so mean." I'm like, "Why was that? It's just whatever." So now I gotta call him, but I can call him the Kenosha Shooter, but I can't call him the Kenosha Kid. It's
even though he is a kid that was in Kenosha.
Kenosha Kid sounds pretty good to me. It sounds pretty badass. I like it.
That sounds like a Western to me.
I thought it was.
Yeah, it does for sure. Well, I know all of us we were just talking backstage about like the crazy influx of people that we've all gotten because of this trial. And I mean, I know that the Ahmaud Arbery trial is also going on, and it's so frustrating because I want to cover that one too. Yeah, but it's like we all just, it was like, I mean, Nate, you're covering the Ahmaud Arbery trial like really, really well. But the rest of us kind of just like I think for me at least, it was partly because the Kyle Rittenhouse trial just kind of started faster. Like they got into their opening arguments and their case in chief and whatnot. So it was just by the time that the Ahmaud Arbery, opening statement started, like I had already kind of gotten hooked on what was going on in the Kyle Rittenhouse trial. So I just wanted to stay there. But yeah, I mean, like the growth has been insane. I don't know how you guys are feeling about it.
Too much law happening at once. I can't, I literally can't keep up. Yesterday I was doing the Fifth Circuit decision on the OSHA thing, but I still have to do the other U.S. Supreme Court audio from the SB 8. I still have to do the Katie Joy thing, and I still have to do Ahmaud Arbery. And I think on the Twitter, I put a list of things. I think it was down to like 10 things that are trying to compete for my attention. It's just impossible. One bite at a time isn't working anymore. We're in the Lucy episode with the assembly line and trying to keep up, and it's not happening.
Yeah. So before we get into everything, I did want to say that thank you for everyone that has come onto the channel and subscribed and followed on Twitter and all this great stuff. I've gotten some people asking for merch. I feel kind of silly about it because it's just, I don't know, I feel a little sheepish about it, but you know what? I'm going to go with it. If people are asking for it, I'm going to provide it. So I actually just made a Teespring store, which I have linked in the description below, and I will show you guys what some of this looks like. So we have a little bit of Legalbytes merch. We've got some t-shirts. You can it's kind of hard to see there. Let's try a different color. There you go. So t-shirts, we've got tote bags, pint glasses for your White Claws. We've got mugs, black mugs, white mugs for your pumpkin spice lattes. All your great basic stuff.
Can I get a temporary tattoo with that logo? That'd be badass. Put it right on my bicep.
You know what?
With this trial, be great.
I don't have it. Yeah, you could get a permanent one. I don't have any temporary, but I do have a die cut sticker if you're interested.
It's quick. I think Joe's in the back. He's trying to get in.
Oh, is he?
He wrote up.
I saw him say hi. I don't know if he's back there.
Oh no, I don't. Yeah, I don't see him backstage yet. Oh wait. Oh, I do. I'm so sorry. Oh, he is there. I'm so sorry. No, you were on the second level. It was. I just scrolled down a little bit. I'm so sorry, Joe.
No, that's okay. That's okay. I'm sorry I'm late. I was busy. I was busy there donating my hair and got held up.
Yeah, no worries. Well, I'm so happy that you're here. So and also the last person that said that he might pop in at some point is Viva Fry. He's on the road right now, so I'm not sure if he's going to make it, but he said that he might. So
well, he's in his office.
Yes, he's in his office, but it happens to be moving. And who knows? Maybe Legal Mindset is also in his office. We don't know. But
his office, it's like when I go to the office, right?
That's right. Can I say one thing now?
Mm-hmm.
Listen, for everyone, thank you to Nick Rekieta.
Yes,
he has been amazing for all of us. I'm talking about, he's just, all hail the king. The fact that he's been so gracious and so understanding and allowing us to come in and share our thoughts with that massive audience, it's been wonderful. So, I know he's not here today, but Nick, he's done more for, I think, all of our channels than anyone else could have done. And, we definitely want, I just wanted to personally give a shout out and thanks to Nick for everything he's been doing for us for the past.
Yes.
So,
thanks.
Completely agree.
He's really just been Nick. That's who Nick is.
Yeah, he's just been
Nick. And that's I think the biggest comment I can give him. So,
I'm pretty sure I've told you all, both publicly and privately, that one of the things I really hoped to accomplish was really creating a legal community, a new academy. I think I've used those words, and Nick has basically accomplished that. And so I'm just thrilled from that angle that we really now have, because we've of course all interacted together, privately as well. But I think that Nick has done more in the last week to really make that a cohesive thing as a joint venture than anyone else has done to this point, and that's been a really thrilling part of this exercise for me.
Sorry guys, I'm adjusting the volume for everybody because I just realized that only my volume is back to
Also, the extra
normal
5,000
levels.
subs. The extra 5,000 subs has been nice, so I'll take that too.
If you
of
go
course.
and click, there's like a little button that says or the
automatically adjust.
automatically do it, and you can do it for everyone. So then we don't have the.
Yeah, I just did it for everybody.
Awesome.
So okay, thanks for letting me know, chat. So it's been a pretty crazy week for all of us, and yeah, like 100% agree that I mean, Nick is awesome, and it's wonderful that he invited us on, and that he did the live stream in the first place, like because all of us had pretty much we had all covered it at least to some extent the Derek Chauvin trial, but I don't think anybody really thought of like actually live streaming and commenting during the live stream for that one. So I mean,
no, we did.
Kudos.
We did. We
did to some degree.
We did like me and Joe. We did like the last week of it, and it was huge too. It was like, well, how many did we get? Like 15, almost 2,000 live viewers.
It was very
popular.
I'm not sure if we went before closing arguments, but yeah, I mean, I think that you're right that people we saw the interest level was through the roof.
Yeah. Okay, so I stand corrected.
Yeah.
We had done it before, but we didn't do it to this extent. What Nick did was just because he did
Nick,
wall to wall. We cut it off like maybe 2:00 though. So
yeah.
And Nick with king of all the super chats.
Oh my God.
That man with the super chats. He doesn't even know how he does it, but he is one of the most popular super chat people anywhere, especially
on
when
the planet.
He was number 6. He was number 6 in the world and number 1 in the United States for a week straight. So for that week, he was number 1 in the United States, number 6 in the world.
I might need to get a cut of this. Just saying.
Yeah.
So we're getting a super chat and saying that we should invite Legal Eagle to go over the Rittenhouse case.
No, that's
I would. I think. I don't know what.
You know what?
So bad. He's a good attorney. I think. I assume so.
No. If he's going to come on the panel, we definitely have to treat him like a probe. For a while. He's probationary because
I would eagerly welcome.
Yeah.
I would eagerly welcome his opinion, and if he gives you the classic leftist claptrap, I would debate him on it and ask him to prove his point. I think that more exposure to opposing ideas is beneficial for everyone.
You're probably right, but I'm just going to grouse about it, privately at least.
I want to hear people I disagree with because that's how you learn if you're wrong.
I want to hear people I disagree with. I'm just not sure one of those people is necessarily Legal Eagle because I'm not. The reason is because I'm not 100% sure that he's an honest actor sometimes or an honest broker because of some of his opinions. That's why. Do you really believe all this? It's like, I don't know,
that's why talking with someone like that and confronting them, with opposing ideas is also a good idea because then you can kind of see how much of that is honest argument and how much of that is just fluff.
Okay.
So I would also welcome.
You guys are right. I defer to the majority.
Speaking of which,
see, sometimes we disagree with one another, guys.
Robert Barnes actually responded to a tweet by Cenk Uygur, who's obviously a diehard crazy progressive, and the tweet that Cenk Uygur wrote was something to the effect of, "Hey, guys on the right, I know you don't like me. You probably don't like me, and I really don't like you very much. But can we all agree that since we're all against big pharma, that we should start?" And we all want justice reform, that we should start working together. And Robert Barnes' response was, okay, great. Let's hear you speak out against vaccine mandates because it should be against everything that you're asking for. And and there was no response. My thought was, okay, great. Stop calling for us to be canceled and or thrown in jail. And perhaps we can start actually working towards, resolution. I don't think his concept of election reform is anything like my concept of election reform, but yeah, as far as fighting big pharma, I do think that we might have a common enemy there. And to the extent that we can actually find, common enemies, perhaps that is a healthy way for American discourse to move forward. Just a thought.
There's areas of potential for agreement. I mean, at least on the conservatorship thing, the left and right seem to be on roughly the same page and in roughly the same direction at the moment. So that's kind of nice. Maybe we could work on conservatorship reform.
Britney Spears uniting America.
I know. it's really great, and it leads me to the question of what went wrong and when did it go wrong in the whole thing, because I haven't been paying super attention, and I've openly admitted that family law is, by some deliberate choice of mine, my worst area of law. It's like the one I understand the least, and I don't really want to understand it that much because it seems sad. But everything I've seen seems like the right result, and it seems like something went wrong along the way. So I'm open to figuring out what that was, assuming that something did go wrong. So
I remember when I was taking Barbary, which is the bar review course that like 90% of all prospective attorneys took back in the days before cement was invented. We all took Barbary, and so they would cover different topics, and some they would spend 3 days on, some they spend a day on. When it came to family law, they said, okay, just remember whatever's best for the child. And that's all I know about family law also. Whatever is best for the child.
Which may be all you need to know, given the way some things seem to be going.
So
sounds like it's not that different in the States than here then.
It's the how many factors is it for the test? The best, I think there's like 25 factors to determine if it's in the best interest of the child.
Oh, is it?
Like some it's like a crazy
I thought
test.
I thought it was just the one factor. Okay, so there I thought it was just I don't know what I'm talking about.
I think
family
I have
law.
it here. See. Well, I'm actually gonna retake. I think I'm taking the Florida bar, so I have that.
Yeah, I think I'm going to take the Texas bar, and I think I'm taking the Texas bar in February. I need to work.
Nice.
I think I'm good on my multiple choice. Does anyone know of a good way to practice on the essays? Because I could probably use help there. Is there a good website or something for essay practice?
I just wrote and rewrote. That's what I did.
Because it's not about. But the essays is not really about substance; it's about form. Like as long as they can follow your argument, you're going to get the essay questions. And don't,
speaking of the bar, I just want to give a shout out. I don't know if he's watching, but Patriot J, aka Sir Hottest, who was once a guest on my show, passed the California bar exam this weekend. So if you're watching Patriot J, I want to give you congratulations. Great work there, passing on the first try. It's really awesome. And those of you who don't follow him should, because the guy he's based as hell, and he's a great follow. So just thought I'd throw that out there.
Yeah.
He goes by @Sir Hottest, in case you're looking for him on Twitter.
I'm always up for Nick's big brain panel. It's always a lot of fun. Is that what we're doing now, though? Kind of.
That's what I thought. I thought we were already on the big brain.
This is Nick's
panel.
big brain panel. We're 40% of the brain right here.
I know. Yeah, exactly.
I think we're more like 70% of the brain, but okay.
Mike Keeney says that we should invite Andrew Branca to the panel. I'd be interested. Why not?
It's your panel. Go nuts.
All the invites are from Nick, I think, right? Or you mean this panel? Yeah, if you can get him on, sure.
Sure. Yeah, but I think
Kyle.
As far as Nick's channel is concerned, that's all his decision. So Nice Lizard says, I want to know your guys' thoughts on tomorrow. So
I'm keeping my fingers crossed that weapons charge is going to be dismissed, because that's a huge thing for Kyle.
Yeah.
That happens.
Yeah.
I think the defense got the best argument though for the dismissing weapons charge. Because
I think so too.
Two reasons. The two reasons for the weapons charge should definitely go. Number one, the prosecution didn't offer any evidence to barrel length. Now, for those of you who don't know, the prosecution has to prove every element of the offense. So, for instance, it's not enough to say, well, he didn't have a license, right? You have to. They have to go to the DMV and say, well, he didn't have a license, and with the DMV, which is something crazy because the defense kind of conceded that. Well, he doesn't have a hunting license, but they didn't. They're supposed to go to the hunting agency, says he doesn't have a hunting license, and prove that he doesn't have a hunting license, but they didn't do that, and the defense conceded, which is ridiculous. That's like almost malpractice here. But then even conceding that, they still would have to prove how long the barrel was, because there was a barrel exception. They offered no evidence to show how long the barrel length is. So with no evidence, the jury conceivably cannot say that the barrel length was illegal, and i.e. that's the reason why.
Well, they can't offer any evidence because the barrel is in fact not short enough. So they can't offer any evidence because all the evidence and someone pointed out it's probably in the ballistics report. So there's probably a piece of evidence somewhere that says what the barrel length is. That's on the record.
On that issue, which they argued about this on Friday, and someone shared with me a link that I was planning on sharing publicly and hoping that it got spread out enough that defense counsel will notice it. When you look at the very opening of cross of the detective, I don't remember, he's got a long name, Andronidi or something like that. So the one who sits at the table there, guy with the goatee who sits at the table there. So if you look at the beginning of his cross-examination, which was done by Sharifisi, he comes out of the gate asking him whether he measured the length of the barrel and whether or not that barrel was a violation of law. And he actually admits that it wasn't. So that's something, I mean, and then later on, they all forgot about it days later when they were talking about jury charges and things of that nature. And Binger was denying the fact that the length of the barrel ever came up, and he never brought it up, nor did his co-counsel. But Sharifisi did.
If it never came up, then the prosecution loses.
Right.
Well,
because
that was a great moment from the prosecutor during the arguments on Friday. It's like, well, they never offered any testimony about the barrel length, and the judge is just looking at him like, what? It's your burden. You're the one who has to offer it. It's like, they never brought it up. I would like to remind everyone the defense can do jack shit and win. That's an option.
Yeah, that's right. Exactly. You start off with assumed innocent. That's part of the whole American justice system. At the same time, they were making a stink that there's an onus on him to raise that defense, and that has to be brought up somewhere during trial. Otherwise, it's assumed. I don't know if it's under Wisconsin law or some sort of technicality. It's assumed to be admitted by the defendant, and they said at no time was it brought up during any questioning, and that was the big issue they raised. And and this video clip, the first 90 seconds of the cross of that detective refutes even that last claim of theirs. So hold on. That's why I think that clip is important.
But for the barrel length, Joe, the presumption of innocence is not a state rule. That's a constitutional protection, right?
I understand.
So if there's an element of the crime like barrel length that had that, it has to be X amount, and they don't provide any evidence to show, then that's it. It's done. You now have a constitutional violation. If the jury convicted them and said, okay, we believe it's there without any evidence, it's over still. That's an appealable issue.
You're saying okay.
And they're trying to claim that it's an exception that he's trying to fall into. But I mean, I'm not a Wisconsin lawyer. I'm just looking through the statute. It actually looks like it's the opposite, that the short barrel is an exception to the otherwise rule that it would be okay. Yeah. So again, that would put it on the prosecution to have to measure the barrel, not the defense. I don't understand the argument, and sometimes it's hard to tell if Binger is not good at his job or just trying to confuse the court. And I kind of worry it's the latter one.
There's talkers and there's writers, right? That's how it was when the DA's over. Like, you had some people who write like beautifully. They would get in their time capsule and write, but then you had the talkers, the people who would go in and do the dog and pony show. So I think Binger's the dog and pony guy, and the bigger guy, he's the guy who goes into the details. That's why he was arguing the nuances of the jury instruction, because Binger, that's just not what he does.
Right.
I like to think I can do both.
I mean, that's the ideal, right? It's trying to get to both. Well, Joe, here's a question for you. What do you think of the BLM leader in New York calling for bloodshed if he doesn't get his way? I think I might be able to predict what you kind of think about this. But go on.
With the NYPD hat on.
I think he should be thrown in jail. That's what I think. I think if you're calling for bloodshed, I don't even understand any argument to the contrary. I'm not sure how he's still walking the streets, if not for the fact that he's taking a leftist position and that the DA gets to choose who they prosecute. But imagine, just think about it the other way. If someone talked about like calling for bloodshed that was anything but a leftist agenda, they would have the FBI all over them, if not local authorities. So. And I don't think I'm not going on any kind of limb there. Sometimes I'll go on a limb on my political positions, but that's pretty open and shut to me. So,
Joe, when the hell have you gone out of the limb? I've not seen any limb. I've been going on a limb. Abortion, that's a limb. Like, what? Really? Come on, really?
Here's another one. Once Kyle gets acquitted, he should go back to the car dealership with his rifle to troll everyone. LOL, keep up the great work, everyone.
I would not recommend that.
Do that. What do you guys think about?
Yeah.
What do you guys think about the provocation? What do you guys think about the provocation reasoning? That I think is. I honestly don't know if the prosecution is brilliant or if they just kind of stumbled into it. Because all right, so everybody who's a non-lawyer in the chat understands the prosecution. The provocation argument could be fatal to Kyle's whole defense. And the reason is if they can prove, or if the jury believes that Kyle provoked the first shooting of Rosenbaum, the collateral effect of that, right, him being unjustified in the Rosenbaum shooting, has a collateral effect on both the Huber shooting and the Grosskreutz shooting, because those two shootings that came behind it are all collateral to that first shooting. So in other words, if it's found that Kyle murdered Rosenbaum, then both Kreutz, so whatever his name is, and Huber, they were trying to stop someone who just committed a crime. So you're getting into now whether they were trying to conduct a citizen's arrest based on a felony that just had occurred, right? And they had knowledge. He had just shot somebody supposedly in cold blood. So that removes Kyle's self-defense claim against those two shootings as a matter of law because of the provocation. So this provocation attack, I think, is brilliant because it essentially gives the prosecution an all or nothing on the provocation side, where if we can prove that he provoked Rosenbaum to chase him, then we get all the other murders as a coincidence of it. Now, I honestly don't believe I don't believe he provoked him at all, but I think they've given themselves a shot in the fourth quarter.
Mm-hmm.
They're instead of being on the 1 yard line, they are now, I'm talking about, 99 yards away. They're about in field goal range, and that's dangerous.
It's brilliant, but I mean, I'm wondering why this went to the jury, because they're sitting there, they're saying that they spent, 20 hours trying out different Zoom methods. And in one of them, you can kind of maybe see something, which no eyewitness ever saw. Only an officer who is reviewing this thinks he sees it. So how is that admissible? And they're going to put that to a jury that's what the whole provocation thing. It seems to me like this whole argument rests on what is likely a visual artifact of their Zoom process. I mean, they're within field goal range, but we're talking about something where this kid could potentially be convicted purely based on a visual glitch, like a software glitch. And I have some serious concerns with that. I have some serious concerns with why the prosecution's putting this forward. Like, if they know that it only shows up on one particular algorithm as compared to all the others they tried, like, how do you put that forward to a jury in good faith saying this is what actually happened, especially when they've got witnesses who were present? You know, Zeminski could come in and say, yeah, he pointed a gun at me, but that's never happened. They're actually keeping that from, they're not calling that witness. And I mean, what's the only conclusion that we can make? It probably is because Zeminski would go, yeah, no, I didn't see that. I didn't see anybody point a gun at me. They're manufacturing a story here.
But just with the Zeminski piece, Zeminski has charges against him, so he has a Fifth Amendment claim. So they can't even call him in to testify, even if they wanted him to, because he's got his Fifth Amendment issues that he's got for shooting a gun, because he's about to be charged with that.
Now, this is kind of strange to me because Canada runs this entirely differently. Here, the way we do it is that if you're being called in your own trial, you've got a right to either testify or not. But if you do, then they can cross-examine you on anything, even if you didn't bring it up in the direct. But if it's somebody else's trial, you actually enjoy a privilege against any evidence being used against you later. So here, Zeminski would be compellable. He'd have to get up on the stand and say, whatever he's going to say, which might actually include criminal acts. And then later, when they're trying Zeminski, they just can't raise it. So he can.
We don't have that.
Yeah, it's very different here. So I don't know. My understanding would be that he'd have to still get up on the stand and assert the Fifth. Is that not how that goes? Or
yes, it technically is, but you can't call him. You can't call him with the knowledge that they're going to do that, because it's deemed to be unduly prejudicial. So you can't call him. You can't call him basically for the sole purpose of him invoking the Fifth. So
but this happened in the George Floyd trial with the guy who actually sold George Floyd the drugs. They were trying to call him onto the stand, but his lawyer came to court and said, well, he is just going to take the Fifth. And they said, well, if he's telling us he's going to take the Fifth, then we can't ask him any questions, and it would just be useless to call him to the stand just to take the Fifth, because the jury can get an unfavorable inference toward this. So in this case, they're just not going to call him.
Yeah, we actually do believe in the right to remain silent, which is one of the reasons the judge was going so crazy about it being against Kyle. And I don't know. Someone has to explain to me in like kindergarten level why the defense did not re-raise that issue. I mean, the judge seemed mad, and it seems like it's technically pending, but why didn't they just start the day where the judge was at the very start of Friday, where the judge is like, how about jury instructions? And the defense is like, how about not jury instructions? How about we talk about that motion to dismiss with prejudice because of the Fifth Amendment issue, or at least re-raise it. And because then the judge can go, no, we're going to do jury instructions. And then you go, okay, but you at least re-raise the issue.
I don't even get why they don't ask for it right now, like right when the judge was pissed.
Yeah,
the judge is still furious. He's yelling at the prosecution. You just say, we'd ask for a mistrial with prejudice. And he might say, I want written submissions on this and send it back to let him cool off. But he might not. I mean, raise it. I don't understand some of the tactical decisions. And I'm sort of going, is this because I'm Canadian and we have different things here? Or is this because it's just bad?
It's not that.
I mean, there is a but there is also a possibility that there could be some local Wisconsin cultural ways of doing things that are different from where we're all used to doing things. So I don't know. I always try to keep that in mind. I'm having a hard time buying that
to this degree.
I completely understand, and I'm not necessarily saying that I'm advocating for that that reasoning, but I'm just kind of throwing that out there.
I'm just a simple country lawyer, can only go so far, my friends.
No, let's not forget also preserving the rights from appeal, right? You at least raise it, and so in every state and every jurisdiction, you have to preserve your objection so you can when you appeal, you don't have to. So I would have just thrown it out there for that.
You can make an argument. You can make an argument that if they don't re-raise the issue, that it's waived, that they then preserve the objection. Yeah. So now that Fifth Amendment issue might disappear on appeal. That's how stupid all this is. How can they be this stupid?
The last thing you want is a situation where your appellate lawyer is in the position of either going, well, I can't argue the things I want to argue unless I can get ineffective assistance of counsel on the table. Because at that point, somebody else is running an appeal on whether you're terrible at your job. And nobody ever wants to be in that spot.
I'll do it. I'll do it. I'll run an appeal on whether it's terrible job. I have no problem with that.
We have another question, this time for Ian. Hey, Runkle, what's your doggo's name? And can you show the doggo here today? Asking for a friend.
I've got two.
You have a dog? Oh.
I've got two, Zora and Potter. Now, both of them are asleep. And at least one of them is a little big to pick up for the live stream. But I'll see if I can get them, or at least find a picture here. I can pull that up fairly quickly. So maybe I'll throw a picture up in a moment, and then we can throw that in the chat.
That sounds good. So somebody also wanted to know if we've watched the Law of Self-Defense YouTube channel. He was really good as well. No, but I was watching his tweets. So I thought he was only on Twitter. So I thank you for asking, because now I'm definitely going to go and subscribe. Because the tweets from that account were really good.
Yeah.
Have you guys seen it?
Excellent. I've watched him for a couple of years. He's really good. Well, I'm just going to say it. He was wrong on the Chauvin trial. He was just dead wrong, and he got it wrong. But, with the rest of the stuff, he is like all on point. So, it is what it is.
Yeah. So let's talk about the, I don't know. I'm sure you guys have been getting a bunch of like DMs and emails and stuff about this, about the pixelated images that were submitted by the prosecution. I know everybody kind of seems to agree that those probably shouldn't have been admitted, because the thing that's so frustrating to me about it is that the reason why those shouldn't have been admitted, in my opinion, is because in order to admit something that is technologically involved, you have to introduce it through an expert, and that expert has to show that this is not junk science, that this is proper, right? Because junk science is a thing, and courts are very, very try to be very careful about keeping out junk science. And here we go. Thanks, Nate, for pulling this up.
For the last 10 minutes, you haven't heard me say a word because I've literally been biting my tongue because this I'm serious. I have not said a word. I've been sitting here just because I was like, I don't want to take the show over by starting a 20-minute rant.
Let's do it. Let's go. People are here. Rant. Joe, people were asking for you in the
4K,
chat.
When you take like 800 pixels and you expand them to 4K, it means literally you're putting in 3,200 pixels. That means 4/5 of that picture is fake. It's just imagined. Now, let's also consider the fact that he went magically from not holding it at any height up in one frame in a millisecond. All of a sudden now, like magic, it's like almost like a slip thing, like from the movie Fight Club, where the guy's inserting a frame in the middle of a movie. I don't know if you guys remember. thing
Yeah.
in Fight Club where he'd he'd sort of frame offensive pictures in the middle of the movie just to make himself amused. That's what this frame is, because there's nothing of him raising the gun up. All of a sudden, it's just like, boop, here's a picture where we think he has his gun up. But how about raising the gun up like, 2 milliseconds before? You don't just all of a sudden magically go from being in one position to having your hand up with the arms raised. There's been video evidence which shows that the thing which is supposed to be supporting his hand, the hand that's supporting the gun, is actually there on the car the entire time. So that's not even his hand that's supporting the gun. That's actually behind him. It's actually a spot on the car, like some dent or something like that on the car that's behind him. So it's got nothing to do with anything. This picture, this doctored, ridiculous, stupid, artificial picture has been used to promote that provocation claim. And the whole reason they want this provocation thing is, I'm telling you now, we will hear tomorrow in closing arguments the theme, if the state has any brain at all, which is questionable, but if they have any brain at all, what they will do is they will make this entire story a story about Kyle's provocation, that he showed up that night for provocation, that he was provoking Yellow Pants with that ridiculous, stupid story, and that this was the final provocation. And they're going to say his goal all night by showing up there in the first place, even without a gun, was to provoke them. Then having his gun around is to provoke them. Making a joke at someone saying, I love you too, is a way of provoking them. Then he goes to Yellow Pants and he's provoking them. And now the final step was him provoking them with this stupid imaginary nonsense thing that never happened, that no one saw, no one testified to, has no proper foundation in law or basis, and that this was his provocation. And because of this provocation now, you should say he loses his right to self-defense. When everyone knows, first of all, people aren't even sure if this is Kyle or Zeminski himself in this stupid picture, but everyone knows that the jury here has been hearing the term provocation. Kyle provoked them for 14 months. And they're not going to be looking at this because anyone with half a brain says this picture makes absolutely no sense. So why would I think that's provocation? But what's going to end up happening that I'm foreseeing, I'm terrified of seeing, is that they're going to think to themselves, you know what? The judge is now giving me a provocation charge. And even though the judge, I'm sure if he's any half a good judge, which is okay, if he ends up giving a provocation charge, they're going to say, oh, I guess if he provokes them, well, in that case, now he can't rely on self-defense anymore.
He loses it all. He loses it all, Jim.
Yeah,
that's the key with this.
They're going to use the semantics of provocation to basically say that his all-night provocation now costs him the right to use self-defense. And that's what I'm anticipating is going to be the argument in the jury room. And then what's going to happen is you're going to have some jurors who are sitting there saying, you're out of your minds. This guy's pure self-defense. He shouldn't be there. And what's going to happen is they're going to end up haggling to negotiate down to these stupid lesser included charges. And because of aggravated assault or some other stupid charge that he never, ever should have been advised to agree to, he's going to end up spending 4 to 10 years in jail. That's what I'm worried about.
I disagree. I think this is hung all the way. At worst, I think it's hung. This is classic self-defense. But I do want to say this. The reason why this is even an issue is 2 reasons. Number one, the defense put on Kyle. They put on a case. If the defense rests right after the prosecution is open, and where the prosecution proved their case for them, they put on a defense, and that defense is why we're seeing this thing, right? This is all the defense's fault. The reason why this thing, and the reason why they put Kyle on, because they introduced this when Kyle was on the stand and asking about it. So that is their own fault. But I also think the defense is not arguing the technical aspect of why this shouldn't come in. And think about the chain of reasoning. Kyle points the gun at Zeminski. Rosenbaum sees it and chases Kyle, right? So you need that for provocation. You need that. You need the fact that Rosenbaum saw this. There's no evidence in any of the trial that we've heard that Rosenbaum saw any of this. Now, if this goes to the jury has to make that assumption, even without any evidence. That's how you should attack this. You should attack this where, hey, even if you want provocation, you have to at least show us that he saw it to be provoked. And now you don't, and they don't have that. That's where I would attack this. And I'm surprised the defense hasn't attacked it in this way, but I think, I don't know. It's their case, so we can.
Defense is weak.
The other thing something I've been seeing on Twitter is some of the computer science guys saying and taking issue with this notion of this introducing new information. And I think that's because the computer science guys actually using a different definition of information. So they're saying basically if you take a small image and blow it up, it can't introduce new information because by definition, you can't get any more, you can't get a better idea of what that original picture was. Whereas a lawyer would say, yes, it can introduce new information, because if you get a visual artifact that looks like a person, or looks like a silhouette standing in the shadows, that to a juror is information, even though to the computer science guy it's not, because it's just a fake bit of garbage. It's actually entropy to the computer science guy. So it's resulting in a bit of a distorted dialogue that I'm seeing online, but people aren't really getting the issue here, which is, how do we know what this blob is? How do we know that this isn't just, a reflection on the car that's being changed to look like an arm? And the other thing is, we know Kyle's handedness, and this picture would suggest that Kyle has suddenly switched shoulders. Now, that's something you might do in a 3-gun match or something where they're forcing you to do it by stage design, but it's a pain. I don't know how many people have gone and shot these kinds of events where you have to switch over. It's actually quite
in a sling. It's not just loose, but in a sling, it actually takes 2 seconds. You have to sling it over. You can't just do it in half a second. You can't just do it in a couple milliseconds.
This would actually be a really pain in the ass kind of thing, right? It's, it's not the sort of thing you do just casually. So it's a weird step to say that suddenly not only is he just pointing this gun in this one frame, but that he's also doing it offhand. Is, why would you ever just do that offhand if you could not do it offhand? Right. I can't believe this theory would make any sense here, but I'm just horrified by watching this, with the possibility that, as you say, they get the provocation argument in, and I'm seeing people in the chat saying, oh, well, he was provoking him all night by his presence. It's like, that's not the legal test. People are just...
No, but I think I agree with Good Logic more than Nate the Lawyer, and I think Nate the Lawyer and Rakita are more in agreement together than... Anyways, but... I was trying to make a point and I lost it. That's fine. Anyways, with respect to Nick. Whatever. With respect to the provocation argument, we as lawyers, because of reading cases and understanding, we have a pretty good technical understanding of what provocation means. The problem is, based on these jury instructions of what provocation means, and I went through the model instructions on my channel, that the language is open. It says that you have provocation if you have an unlawful act. And then there's a footnote that says, well, unlawful act can include a civil unrest. It can include disorderly conduct, I believe was the exact phraseology. If you have a disorderly conduct, that qualifies as an unlawful act that would predicate. So it's like, okay, so now all I have to conclude based on that instruction is that Kyle Rittenhouse was engaging in disorderly conduct. And if I'm predisposed to not like Kyle for whatever reason, how easy is that? We know it's not legally disorderly conduct, but for an average juror, trying to interpret this language, I think the prosecution, I think Joe's right. Basically, all you have to do is hint, if not outright state, because the defense is not going to stop you. You just have to outright hint or state that he was engaged in disorderly conduct the whole night. It was disorderly conduct for him to come to Kenosha. It was disorderly conduct for him to bring his rifle. It was disorderly conduct for him to come to a scene that he knew from previous day was volatile. He knew it was provocation or provoking to try to put out fires because the people were saying, protect your property, not the streets. So he knew that trying to put out fires was provoking, and his entire presence was provoking. So you just have to hint at it, and you're there.
I think I do need to just to clean up the legal standard here on what I'm assuming the prosecution has to kill with the provocation. All the other stuff that happened in the night, it's relevant in the sense of he's trying to go into his state of mind. He's going to provoke, but what they have to show, right, that gets them the whole game, is that in that moment when he pointed the gun, well, he allegedly, I don't want to even say because I think it's all bullshit, but if when he allegedly points the gun at Zeminski or whatever the guy's name is, not only did Rosenbaum see it, it provoked Rosenbaum to try to stop him, right? And pointing a gun at somebody, you got your disorderly. And then him running from Rosenbaum, because even the prosecutor said he retreated, but he didn't announce that it was over. That's their whole theory. Their whole theory is not even about the night and all that stuff. It's really just about that moment If he pointed at the Zemeckis, that's your disorderly. That kills his self-defense for the next three shootings. That's the problem that Kyle is running into now. But I think they lose. I essentially think they're going to lose, but it's possible they win. It's possible they win.
Let me get this super chat real quick. Oh shoot, sorry. Okay, give me 1 minute. I'll find it. I thought I could just click on it up top.
Damn, there's so many coming in. I'm like, whoa, wow.
I know. This is a wonderful, beautiful problem to have. Thank you so much to everyone, by the way. I know last time Good Logic got annoyed with me because I kept thanking each individual super chat.
I didn't get annoyed. I was simply saying, I was recognizing
there's no way today.
I was recognizing that you've reached a sufficient size now that you can't people don't want to hear it even. They're just like, they know you appreciate it. And I think you're so humble that you don't appreciate the magnitude of your size already. That's all.
Well, thank you. It's true. I am having a hard time wrapping my mind around it. But I guess we'll get there, right? So Daniel Henry says, software engineer here. Interpolation is designed not to introduce detail, but enlarged images can be misleading by falsely suggesting the absence of details. Fabricated evidence of absence should be enough to make enlarged images inadmissible. So yeah, and that seems like what Shirafisi was getting at with drawing the little boxes, right? And then the missing boxes in between, saying, well, what goes in between? How do we know what goes in between? How can we be certain of that? And I think that if they can use that illustration at closing, I think that is an effective way to explain just how unreliable that particular evidence is. And if they can convince the jury of that, then no problem. Then they have all of the other evidence for the jury to listen to and to look at, to show that he wasn't provoking anyone. So.
And yeah. I mean, something that is initially a strap, like I played around a little bit with taking a bunch of different images, downgrading them, and then trying to blow them up again. And you can get something that is, a reflection or a strap or something like that. And by the time it's changed, it can look like something completely different. That could be a reflection off the car because there's weird lighting in this situation. There's fires, there's lights on, there's lights off. And that could turn and look like a hand. You don't actually seem to see this in the actual video as they're playing it. It's only when they're like, here, look at this one frame. It's really easy to get that sort of deceptive thing where something can look like something it's not because you've blurred it and you've, enlarged things. So something that was thin can end up looking a lot thicker than it was, and that kind of thing.
Yeah, absolutely. Here's another question. I'd appreciate it if each of you could lay out your own over-under on full acquittal. I've been heating up a really spicy Twitter and raging meme in Premiere all weekend, and I want to know if I should keep polishing it or not. So what do you guys think? Kurt, how about you first, since Nate's out?
Well, where we're sitting right now, and that could change based on whether or not the weapons charge. So these numbers will change based on whether or not the weapons charge is dismissed. And it'll change based on the closing. But based on where I'm sitting right now with the provocation instruction in place, I think it's more likely than not you're getting a guilty on some version of a top count, whether it's compromised or not. So I think your odds of guilty are probably... Because also I'm going also basing this on what Robert Barnes said. Robert Barnes said when he was doing his jury consulting work that in Kenosha, which is apparently one of the more favorable places for Kyle, but even though it's favorable, 2/3 started out opposed to Kyle and 1/3 were just dead set against him. Like there's a third that was immovably dead set. So I'm also basing it off those numbers. So I'd say the probability of him being convicted on some version of the top counts or reckless endangerment, I think at this point is 70% too high. It sounds too high. I don't know. It's not. I think it's more likely than not. So 70%, I think, is. Yeah, I'm not a happy camper about it.
For conviction. Wow.
For conviction, yeah. For some version of conviction, yeah. For some version of the top count, for either some version of the murder or its lesser includes or the reckless endangerment, I think you're looking at a 70% chance of one of those charges becoming guilty based on where we're sitting right now.
Ian, what about you?
I kind of give it 50% on acquittal on the top counts, with a substantial chunk at that point for hung jury. I do think there is a possibility of conviction on those, but I put it as lower than Kurt does. I think the prosecution has spent enough time pratfalling on their case up till this point that they probably will have convinced at least a couple of jurors that it was self-defense before they got here.
That's
and
true.
Now they're going to come back and say, hey, look at this pixel. Look at this pixel. I think it's unlikely that they're going to sway people on that, especially because it's coming late in the day at closing. These jurors are going to be like, why didn't we hear anything about this before? But I don't know. I give it, say, 20% chance that he gets a conviction on one of the three big ones. And I mean, that's odds. I don't think it scares me that that's the odds I'm sort of thinking in my head here. Like, that's too high.
Oh. Yeah.
I think there's like a 2% chance that he's found guilty on murder, on any of these murder. I think it's very, very low that they're going to find him guilty on murder. I think the lesser included terrify me, especially with the whole speech that they can make about provocation. And that's why I think, as far as him getting one of these lesser includeds for a multiple year sentence, I would go higher than Kurt. I think it's 75%. I think they did such a terrible job there that I think those lesser includeds, he's going to get caught on one of those by a jury that ends up haggling with itself in order to try and wrap this thing up and not end up hung.
I'm more with Ian on this one. I think that the likelihood is lower than what you guys are saying, but it's still higher than it should be for this kind of a case. I think actually the highest likelihood, honestly, is probably actually having a hung jury, because I think that there are so many impassioned people on both sides that I can definitely see somebody on the jury being someone that's a LeBron James type that had already made up their mind and made their way onto the jury, because people do. And then there's also the possibility that somebody could be honestly looking at all of the evidence here and saying, I don't see him provoking anyone. I don't see him chasing after anyone. I see other people chasing after him and him using self-defense. So I think most likely it's going to be a hung jury, but I could see a conviction on some of these lesser charges, not so much the big ones.
Is Nate here, or is he he's muted?
He may be checking on the kids or something.
Nate went out before he wants to put his numbers right. I don't want to be right, by the way.
I would love to see a full acquittal, and I think he'd not just love it. I don't under the law and under the facts, I don't think any conviction on any of these charges is justifiable. I just worry about I worry about the ability to trust 12 people that they're going to understand the law.
Binger was really good on his opening. So if Binger's given, for as many problems during the examinations, both direct and cross, he was really good on opening and setting up the thematic elements. So if he does as good on closing as he did in opening, and if Richards closes and he does as good as he does on closing as he did in opening, then I'm feeling a lot better about my 70% predictions. Yeah. Because it's like, this is not going great. So defeat from the jaws of victory is where we're sitting. This is just
I don't get close to Richards, guys. Come on.
I think an interesting conversation is how, assuming Richards would transmorph into someone better than he is at being a lawyer, like if you were sitting there as his counsel, how would you frame closing arguments in a way that's going to move their hearts rather than being technical about the law? Because I don't think being technical about the law really is very powerful when you're talking to a Midwest jury.
No. You want the story, not the technical aspects. If there's a common idea, if you're explaining, you're losing. Right. And I think that's basically correct. You don't want to be explaining. You want to just have the story, and that's why I think having too much of a reliance on expert witnesses often is a little bit of a death trap for people, because
those kinds of witnesses are great for providing some scientific, background for somebody to logically explain something. But when it comes to the actual emotions that are going to be driving people, I think that's a little bit, that having an over reliance on those kinds of experts is not particularly helpful. But also that's why I really think that Kyle Rittenhouse did a better job on the stand than I think
damn straight
we were all anticipating, because he remained very emotionally consistent from his direct examination through his cross-examination. And I think that's why, like, there were parts that, I mean, we've all talked about the defense not objecting on all kinds of things throughout various witnesses' testimony. But I think that in terms of Kyle's cross-examination, I'm still not entirely convinced that it was that big of a problem that they didn't object during his cross-examination, except for, a few parts, obviously. But because really, I think that the emotional part is really the part that most people were looking for in his testimony, in his direct and his cross-examination. And so if he was remaining emotionally consistent, I think that probably is really the most important part. I don't know. What do you guys think?
I think they need to start off by first emphasizing, Kyle's connection to the community. He's a local kid, even if he's living 10 minutes away or whatever it actually is by car. That this is his community. He was called to help. He shows up. He's seen cleaning graffiti. He's seen helping people. He's seen calming down fights. That's what he's doing. That's what he's there for. He's trying to protect his community. He's trying to help out. And then we have Rosenbaum, who we see is starting fights everywhere he goes. He's a time bomb. He's a grenade that's just kind of floating around here. And Rosenbaum threatens to kill him. He says, if I get you alone, I'm going to kill you. Mm-hmm. Kyle gets separated from him. He's alone. Rosenbaum comes upon him, looks to make good on his threat, charges him. What is Rittenhouse, a 17-year-old kid, supposed to think when this muscled, I mean, he's short, but he's a muscly, imposing, scary guy. He's loud. He's in your face. He's charging at him. He's got, a moment to think, what does he do? He's got a rifle in his hand. He runs. He tries to run. What stops him from running? He hears a gunshot behind him. Is he going to be able to outrun a gunshot? No, he's not. He turns to see what's going on. Rosenbaum is almost on top of him. He tries to run away again. And only when Rosenbaum makes it impossible, he clearly cannot get away, does he turn, and he still waits. He waits until Rosenbaum's hand is literally on his gun, the last possible second before he pulls that trigger. Yeah. He pulls the trigger 4 times in immediate succession, less than a second, as fast as he can until the threat stops. And at that point, what does he do? He's panicking. He stays as long as he can until the mob makes it impossible, and then he flees for safety. He goes to the police. He tells people he's going to the police. He's open about it. He's not threatening anybody along the way. He's just saying, I need help. I need to go to the police. It's only when those people take it upon themselves to attack him, when he's not, he's not an active shooter. He's not threatening anybody. He's saying, I want to go to the police. They could have walked with him and said, let's get you to the police. That's where you need to be right now, is with the police. But instead, they take it upon him to attack him with lethal force, with a skull-crushing hit to the face, with a hit with the skateboard, by pulling a gun. And in each case, he's showing restraint. He does not shoot at people who are retreating. He does not shoot at somebody at Kreutz when he has his hands up. He only pulls that trigger again when Kreutz takes his hands down and puts a gun to his head. Had Kreutz not done that, he would not have been shot. What we see here is somebody who is at every stage not wanting to kill anybody. He wants out of this. And I mean, I think that's really the story you got to tell. He's a local kid. He cares about his community, and things go bad because of I think Rosenbaum is the bad actor here, and you need to really point that out. This is a tragedy.
Yeah.
You know, I don't know if Kreutz is a bad person or not. I don't know if Huber is a bad person or not. I mean, but I don't like Kreutz how he came off on the stand, and I don't think the jury will either.
Or in the media afterwards.
Yeah,
but I don't think you need to. I don't think you need to paint him as a villain. You can just say, listen, you know, he's trying to do what he's, you know, thinks best, but he's wrong about it. He's, you know, this is a situation where it's a tragedy caused by this violent, angry, aggressive person who was looking for a fight, and that's Rosenbaum. And I think if you can point to the jury to thinking Rosenbaum is the problem, that they're going to say, yeah, let's not convict Kyle. And I think that's the proper. That's sort of my thoughts on it.
Essentially, what it's coming down to is who provoked it. Was it Rosenbaum or was it Rittenhouse? You know, who the jury is going to believe?
I love everything you just said there, Ian. I thought that was great. I think the only thing I would add on to that, there's only two things I think I would add on to that, and that is I would actually throw at the jury and say, a man who threatened that if he got you alone, he's going to kill you, and he's charging at him, screaming "F you," and he still doesn't pull that trigger. He waits, and he waits as he's backing away. The guy's screaming "F you," charging at him with rage in his eyes, and he waits until the hand is literally on his gun before he fires. And everyone who died trying to grab his gun. Okay, this guy Huber, ask yourself, would you have waited that long? I wouldn't have waited that long. I don't know very many people at all who would have waited that long, but Kyle did because he didn't want to kill. And then you have Huber there, who literally knocked him over with it, swinging a skateboard at him, and then swung it at his head again. And he's dazed while Huber is fighting for his gun from him. Would you have waited that long before firing off at Huber? I don't know that I would have, but Kyle did because he didn't want to hurt anyone. And then when Kreutz comes running up to him holding a gun, he says to himself, and he's all dazed, and there's a mob around him. Does he fire at him? No. He waits until Gage Kreutz turns his gun and aims at his head. And then he doesn't even kill him, which I think a lot of people may have, but he didn't. That's the restraint that Kyle showed. And I would also add in there that as far as community, you know, the prosecution loves to throw out there about how they're trying to make this case saying that he shouldn't be there. They shouldn't have been there. That we should let Kenosha burn. The cops were afraid to go there because they thought if they went there, presumably, that would start more, that would build up more hatred for the cops if there was any sort of friction there. This is his town. And he said, you know what? I want to protect my town. And yeah, I want to go in there. I want to make sure that if I have my gun there, it's a deterrent. No one's going to bother me. And people who are hurt, people who need medical attention, if there are fires burning, Kenosha's my town. And the same way he spent all afternoon cleaning it, in the evening, he spent all evening trying to protect it and help anyone, no matter their ideology, with any sort of medical aid that they might need. And if not for the fact that some people decided that they were aggravated, that he would not let them burn Kenosha to the ground. If that didn't happen, everyone here walks out of this just fine.
Well, I like what
arguments are tough, though.
I like what Runkle's doing off the top of his head. I like what Good Logic's doing off the top of his head. Nick Rikita was doing this off the top of his head last night and making also very good stuff. And I've done stuff off the top of my head, although I was doing the prosecutions off the top of my head on my stream. I'm sure Legalbytes can do it, too. Yeah. The fact that we can all kind of do this off the top of our heads, and we're all kind of looking at the defense and like, why are you not doing some version of this? Because we're all kind of hitting similar thematic elements, although approaching it differently, but we all have an idea of where we're going that's kind of similar. So why is the defense suck so hard at this, and why are they so bad at this and storytelling? It's like, I don't know. It's like, can we just crowdsource the closing argument because between Runkle and Good Logic and Nick Rikita and myself, we can start just rewriting that and just hand it to them for Monday. Maybe that'll be good.
I mean, the thing is that
Nate, you're muted, Nate.
Can I ask the panel something? all right, so let's say for Gage Kreutz, that guy, even though let's take away the fact his testimony, I think, was staged, all that stuff. And I'm with you guys. I think the version of events that you guys laid out, I actually agree with. I'm voting not guilty. If I'm on that jury, it's not guilty all day. But I'm one of those legal commentators that don't like to get into the group thing. So I'm going to challenge the panel.
Sure.
If Gage Kreutz shot and killed Kyle with the information he had available, Kyle had shot one person. People were saying active shooter. Kyle had shot someone else and killed them. And then Gage Kreutz has that gun and kills Kyle right there dead. Does Gage Kreutz have a viable claim to self-defense?
I say yes.
I would say that there's no way to convict Kreutz on this. I mean, I don't know that he's got a.
Yeah. I say
and
no.
And then for those 3 yeses, for everybody who says yes, that's what the prosecution's argument is going to be against these arguments. Just how everybody said yes to Kreutz, except for
I didn't say
logic.
yes,
but the people, but everybody who did say yes to Kreutz, I think all the reasonable people. Sorry, Joe, I think you're being unreasonable. But I think in that moment, if you could say yes, that Kreutz would have been justified in self-defense or in stopping what he believes is an active shooter with the things that he had, then I think the argument that the prosecution is going to make is that same argument, and that's the liability that I think, or the concern that the defense has to be coming down to.
But I mean, I think,
and that's one thing, that they have to make crystal clear is that the only state of mind that is relevant at all in this case is Kyle's. Not Kreutz, not Rosenbaum's, not anyone else's. They have to make that super clear because because it's funny because normally in a criminal case we would expect the defense to be sort of trying to make things as foggy as possible, as confusing as possible, because the more confusing it is, the more reasonable doubt there is so that the prosecution can't meet all of their elements. But in this case, it seems like it's the prosecution that's trying to make things a little bit murky so that they confuse the jury as to whose state of mind is at issue here. Because if they get them to start thinking about, well, what was Kreutz thinking? What was Huber thinking? What were these guys thinking? Then it starts to make things look really bad for Kyle. But that is not ultimately relevant to the legal analysis for the charges at issue in this case. So the only state of mind that
but push back on it. How many times
I think we need to hear from good logic to explain to us.
I'm sorry, but my last point on this is how many times have we heard this prosecutor say he was an active shooter? Because that only goes to the mind of what they were thinking. But go ahead, good logic.
Walk me through how it is that there could be video of an exchange, a verbal exchange between Gage Kreutz and Kyle, where he asks him, "Where are you going?" And he says, "I'm going to the police." And still Gage retains 30 seconds later a right to kill him in self-defense. Explain to me the logic in that, because I know he claims that he didn't hear him.
The logic is easy because you don't have to believe him, even though he's heading
running directly toward the police.
The guy who just killed one person, you're gonna believe that he's that nothing. The guy who you now seen kill someone else, right? You're gonna believe that he's really. Come on, Joe.
That's not. Go ahead, Joe. Before we all pile up,
he didn't see him kill anyone. He hears everyone screaming, craning him and whatever, and he asks him, "Where are you going?" He says he's running to the police. It's not like he was a mile from the police. The police lights are like 2-3 blocks down, and he sees that
kill the skateboard guy.
I agree with you.
He even claimed that he thought Kyle's life was in danger, which is why he supposedly ran up there. So all of a sudden, he goes from thinking that Kyle's life is in danger to trying to kill him because for some in self-defense. I don't even understand the logic. There's 500 people around him, all chasing him, and he thinks his life is uniquely in danger. I don't even
not
understand
his life.
The logic.
It's self-defense is not only for you.
You're saying defense of others.
It's also defense of others. Yeah. Well, here's my.
I don't
thought.
think it's a good claim. I just don't think you could possibly convict Kreutz on it. I don't think you could get to be on reasonable doubt.
Grossquick's testimony certainly doesn't help his self-defense claim. So if you're basing it on that I would never pull my gun out on something. So a smarter testimony from Grossquitz would have been, I was going up to him because I considered him to be a threat. What I understood was that he was a shooter who had just shot somebody, and he's yelling, "I'm going to the police," and hanging in that direction. But he's a shooter who just shot somebody. So he's a threat to people. So yeah, of course I'm going to go chase him down and the threat, because the police are 2 blocks away. But they're 2 blocks away though. The threat is more imminent. So I'm going to go chase him down and try to stop this imminent threat. So
Because
yeah,
even
I'm going to
so-
pull out my
Yeah.
gun in defense of others, and I'm going to shoot him to stop this threat. So even
And
if I believe he's running to the police, I can get there. Sorry.
Yeah, the way that I see it is even though we had that short conversation with him and saying, where are you going? I'm going to the police. He doesn't have to believe Kyle when Kyle said that. He could be thinking, this guy just shot somebody else. He could tell me anything and I'm not going to believe shit because, I just saw him kill somebody. So, so whatever, he can believe whatever he wants, and he can still think that this guy is a danger to him and to other people around him. And he can still believe that Kyle is also in danger because other people are trying to get him, and still think that he is acting, that Kreutz is acting in his own defense and in defense of other people. So it's all of those things can be true at the same time. So, but that's why, like I said, that the jury has to, be able to parse out the state of mind here, state of mind there. This is the one that matters, is Kyle Rittenhouse's state of mind.
And I mean, the other problem that always comes up, and this is coming up in a lot of discussion, is like one person having a self-defense claim doesn't mean necessarily that the other person doesn't. You can get situations like,
very good point.
If I walk outside my house and I see a guy with a big tool, I might not know that this guy's the meter reader. He's here from the gas company. He's checking the meter. I think he's a guy who's a burglar. He's lying in wait. And I happen to have a firearm. I see this guy, he lifts this thing up in surprise. I think he's coming at me. I shoot him. He might have a self-defense claim if I miss and he goes and panics and bludgeons me and kills me. Notwithstanding the fact that I'm the homeowner, because he's like, I'm here to do the gas. This guy comes out, he starts shooting at me, I clock him. It's a sad scenario. But I might have a self-defense claim because I'm going out to do whatever. There's a guy in my yard with some big heavy object who raises it and I panic. You can, and this might not be the best example, but you can have situations where because of mistakes or whatever else, either side has self-defense as an argument. I don't think Kreutz has a great self-defense claim in the sense that I don't think it is personally self-defense, but I don't know that I'd convict him on it based on all of this, based on the possibility of reasonable doubt. I would convict him if he had shot Kyle at the point where he says, I'm going to the police. That's where I'm going. If Kreutz had said, you know what, I don't believe you, whips out his gun, puts one in Kyle and says, I stopped the threat, I'm a hero, I'd be like, no, you're going to jail. But because there's that further conflict where Kreutz sees this guy, he sees people trying to, and in his mind, trying to arrest Kyle, which might not have been an unreasonable step, right? And he might be assuming these people are people who saw it. He might be assuming, that now he's getting more information. He goes in and tries to help because he sees, Huber get blown away. He's like, I got to get in there. And then he gets shot in that process. At that point, I'd have doubt. Not that I'd be like, I wouldn't be buying a Gage Kreutz as a hero shirt, but I certainly would be going, I don't feel comfortable voting to convict based on what I saw if I was on the jury.
And also because at the moment he was pulling out his gun, Kyle had just shot someone like just now. He'd shot someone else dead in the chest. So he is at that moment shooting people now. So we're looking at from Kreutz's point of view again. So he's chasing him down, maybe with an intent to disarm. Forget citizen's arrest, just an attempt to disarm this guy who is who he believes is a shooter. If I'm seeing someone I believe is a shooter, the idea of, I'm going to go take away his gun so he can stop shooting seems like a good idea. I mean, not necessarily to my own self-help, not necessarily to my own sense of self-preservation, but in the sense of defense of the order, it seems like a good idea. So
if I'm sorry.
Go ahead. No, it's fine.
No, I wanted to ask you if he's running away and there's a citizen's arrest coming on, does that mean that the citizen's arrest you're allowed to engage in a felonious level of aggravated assault to try and conduct a citizen's arrest? I mean, this sounds, I will say this, there's more justification to conduct a citizen's arrest against Kyle than the McMichaels had in the Arbery case. A lot more.
You guys want to talk about that?
I'm just saying there's a lot more justification there, but in the McMichael case, though, which is a terrible case, it's terrible, a terribly tragic story. In that scenario, there they didn't start by beating him over the head and then wrestling for the gun. It was a matter of according to their defense, and I'm not saying this is accurate. I'm just saying their position is that they were trying to station on the outside of the perimeter and use their guns to keep him there as a deterrent to get him from running past them. And then once he grabs the gun, now you have this whole accident. But what I'm saying is the level of felony that's being committed against Kyle before Gage Kreutz waves his gun at him is a pretty high level felony. He's getting hit with a deadly instrument. It's not a deadly weapon, but anything that could be used to kill someone, like a skateboard, is deemed on the eyes of the law as a deadly instrument. And he's being smacked over the head with it twice. So that's definitely a felony under any way you slice it. And I don't know that there's legal justification in Wisconsin. I certainly don't know nearly enough about their citizens arrest laws to know whether they have a right to take that level to try and stop someone who may have just murdered someone.
Well, the way it generally works is that you have to kind of put yourself in the position of the person using the force to determine whether they're number one, their beliefs were reasonable. You have objectively reasonable, and then you have subjectively reasonable. So if you're putting yourself in the skateboard guy, Hubert's position, everybody around him are saying, "Stop! This guy just shot somebody. He shot somebody." Blah blah blah. For Huber, I'm not talking about Huber. Then you have jump kick guy. Everybody's calling him jump kick guy. He tries to jump kick Kyle in the face. Kyle, admittedly, 2 shots to jump kick man. Misses jump kick guy. Huber now, in that moment, has a skateboard. He sees everybody screaming. He's an active shooter and just sees this active shooter get jump kicked and then try to shoot the guy twice. In that moment, it's hard for me to say that Huber, with those facts that he has in front of him, is not justified in trying to stop Rittenhouse, even though his beliefs are wrong. He's wrong, right? Huber, he is not an active shooter, but with those facts as Huber knew them, if I was in Huber's position and if I had a gun, I would have shot and killed Kyle. But Huber had a skateboard and he tried to use a skateboard. So in that position, I think Huber is justified. Then if we go to Kreutz saw those first shots from jump kick man. He sees Huber get shot. And now he pulls out his gun, and if he shoots Kyle there, I also think Huber is justified in that. And I think no reasonable jury would convict Huber either.
That's compelling. You just made a very compelling argument. You made a very compelling argument. But now what Legalbytes said is that that's all irrelevant because we're not looking at it from their position.
Right.
We're looking at it from Kyle's position. And that's the play on words here. The prosecution is saying, look at it from Huber, look at it from Kreutz. And like Legalbytes is saying, that's all irrelevant because we're looking at it as a legal matter from Kyle's perspective.
Right.
That's what makes Kyle's thing different.
Right. No, I was dealing with the whole theoretical situation of, if the other man ends up dead. But I agree with certainly, obviously, the mindset of anyone but Kyle is totally irrelevant. And you actually convinced me with that. I thought it was a compelling argument that in the theoretical situation,
Nate the lawyer's a good lawyer, huh?
In the theoretical situation,
he's not a lawyer at all. We all know the truth.
Yeah, Nate, are you even a real lawyer?
Look,
I know. I'm sure you guys have seen
my
that over
mind
the
is
past
open.
week.
I always say, the thing I pride myself on is my mind is open to being changed. If walk me through it and tell me where I'm wrong, and I think you did a great job there. So kudos to you.
Yeah, I feel the same way. That's why I had good logic on my channel when he was ranting at me in my chat. It's like, okay, I'm going to open it up and let him onto my channel so he can talk to me and we'll have like a respectful dialogue. Amazing concepts at work, right?
Yeah.
So,
let me get another super chat. Why didn't the defense argue timing to recharge an AR-15 rather than waste time on an unspent round not being found? It's impossible to recharge an AR in the time frame. The expert and Baby Binger agreed.
I still don't understand the relevance of him trying to clear the malfunction or not. So okay, accept the premise that he did try to clear a malfunction. Okay, why does it matter? Do you know?
The relevance is that Kreutz is saying, listen, he's surrendering, and the guy goes and charges the gun, which says, hey, I'd like to shoot you. I've just had a malfunction. I'm trying to get ready to shoot you again. And so that's Kreutz is saying that is why he lowers the gun and starts going after Kyle again.
Fine.
Although he says he's not intentionally pointing it, which seems like, how do you accept this? He's saying, like, I think Kyle is about to shoot me, but I'm not intentionally pointing. Like, if I'm in that situation, I'm sitting there surrendering, and somebody points the gun at me, click, and then charges it. I'm not intentionally pointing the gun at him. I'm dropping 2 into him. and repeat as necessary. That's, you know, I find it very incredible that he's got a gun in his hand.
I get that as an element for Gruskowitz. It's like, I don't think you necessarily need it, but sure, it's additionally helpful, right? Because he had just shot Huber and tried to shoot jump kick guy. So I don't think you need it, but okay, sure. So that Gruskowitz has this additional element of why he thinks self-defense or defense of others is needed. Take your pick. You know, I thought I was trying to surrender, but I just saw him recharge his rifle. So that's why I pulled out the gun and was trying to shoot him, except for the fact I just testified under oath. That's not what I was doing, but let's pretend he gave smarter testimony. So even assuming all those things, that's from Gruskowitz's point of view. So legally, it doesn't matter. We have to remember what frame of reference we're in.
But the argument there is that
shift to Kyle's frame of reference.
The argument there is that Kyle is still trying to kill a guy who's surrendering, is the argument. And that then you're saying it's not self-defense because Kreutz is there surrendering. I don't know that necessarily flies, because I don't know if a police officer would not have taken that shot until, say, you drop the gun. You know, even if we accept the premise that Gruskowitz is trying to surrender and that's effective, we need to remember the 100 other people who are currently also there and may not also be trying to surrender. So let's accept the premise. He was trying to surrender. So Kyle would be wrong for attempting to engage him. So he'd be wrong for trying to recycle his rifle to try to engage him. Great, premise accepted. This isn't so much... Now let's talk about the other 99 people who are also there who are posing a threat. This isn't so much a legal argument.
Yeah, no.
This is a jury argument. This is you're trying to convince the jury that, you know, at this point Kyle is snapped. He was just going to shoot whoever. You know, that's what they're trying to. You know, that's a swaying the jury. I don't think I agree with you that logically speaking, from a legal perspective, who cares? But from what the jury's going to think, they're going to think Kyle was about to shoot him. Kyle might be a bad dude. That's, I think, where they're going with that.
And I think you're 100% right. And I think that, I'm not sure who said it first. It might have been good logic, but or maybe it was Legalbytes. I don't even know at this point. But when they're saying, they're trying to confuse the jury by trying to confuse and muddle the issues. It's like, let's look at Huber. Let's look at Gruskowitz. They were acting in a holy way at the moment, you know, regardless of their character traits, which is why we don't bring them up. But at that moment, they were righteous. Okay, you know what? But we're trying to confuse the issue by saying because they're righteous, Kyle is not righteous, and that's not right. But if we confuse the jury with a little bit of provocation instruction, a little bit of disorderly conduct, you know, try to confuse the jury a little bit with a little razzle dazzle. I think it's like we can all keep it straight in the head, but you know, good luck with your average jury trying to do all that. And that's true. I don't know, man. Not feeling great over here.
Let me get a couple more super chats. Have you guys seen Def Not Death's video analyses on Twitter? I know I've seen notifications about it. I haven't had a chance to actually look at them. Let's watch some video analysis, because there was also that Prosobic analysis. I don't know if that's the same guy. But people you guys want to look at it right now?
Let's look at these video analyses and see if they help at all, and then remind ourselves that these video analyses are not part of the record, so it doesn't matter. But let's take a look at them anyway.
The other thing, I'm
going to be listening. I'm just going to turn my camera off because I got wild children running around here. So
no worries. And you guys, and we still haven't gotten into the Ahmaud Arbery trial, but we're going to get into it. I just want to get through some. I just want to get through some more super chats before
those guys are totally guilty. So let's just move on.
One other thing was somebody raised the timing, like that it was impossible for him to charge it in that time frame. Be really careful whenever you say it's impossible for somebody to do something with in terms of firearm timing, because any expert can put up.
Jerry Michalak can do it.
Exactly. That's the problem. You put up an expert, and they're going to say, "Listen, I've been to competitions, and I've watched this guy who's an absolute wizard do it."
I can fire a revolver completely, recharge it, and then fire it completely in under a second because I'm Jerry Michalak and I can do anything.
Right. That's going to be the argument: is Kyle that good? And I mean, obviously he's not. But if you want to make the point that Kyle is not that good, what you'd have to do is put the gun in Kyle's hand, ask him to do the motion. You never want the jury to see the gun in Kyle's hand. You don't want him to see him doing the motion.
Right.
And then you've got a real OJ's glove kind of moment where it's either he pulls it off in a real quick time frame, in which case that's terrible for you as defense, or the prosecution says, yeah, he's just faking it. You know, he's making the glove not fit on his hand intentionally. There's no way to make that look good. I don't think that's an argument you're going to be able to sell in terms of the timing.
Right. So here's the video. So this is Darth Crypto. So he has a new analysis image purporting to be the Kyle Rittenhouse aiming his rifle as a single frame still, algorithmically introduced artifacts and pixelation aside. The image is simply not showing what the DA claims it does. Kyle is not a lefty. Kyle's support hand exists prior to his entry. So here's the video here. I don't know. Tell me if you guys can hear it.
My favorite comment on that fits in with what Runkel was just saying was, if the video is spit, you must acquit. So.
Yes. So this is like two and a half minutes of video. So if you guys want to jump in on something, let me know and I'll pause it. Okay. Let's see. Volume is up. Okay, cool.
So I wanted to do a quick analysis of the video in addition to what I had done earlier. I showed what the prosecution was going to be getting at. I saw it in advance, did a little analysis, and I was able to show you. Now we actually have the prosecution's exhibit in the Kyle Rittenhouse trial. So this is the exhibit where they claim it shows he's aiming the rifle at the committees. Right here, you can see him standing there. This is the edited version, the enhanced version. The one on the right is the original, clearly more pixelated. You can see some areas of distortion, big differences. If you look at the big white sign up at the top, it's a lot different when you see the version on the left, as are some other artifacts. So there are a lot of artifacts being introduced. But what you'll notice about this, and this is very important, a couple things. One, they're saying this is the head. This would be Kyle's elbow bent. This black line right there is the rifle. This over here, right, would be the support hand. Again, you see this white, blurry blub right there. That would be his support hand. That's what they're claiming. So they're suggesting that that's him holding up the rifle. Number one, this would be him holding it lefty. If that's his arm and his elbow bent, he's holding it lefty. And in every single photo, Kyle Rittenhouse holds his rifle righty. He's never been seen in any of the hours and hours of video footage holding his rifle lefty. Now, this is a lightened version of the video, which I did an analysis on earlier, and there's something else that's very important that you're going to want to notice here. You see him run up, drop the fire extinguisher. Runs up, drops the fire extinguisher. I did this in my earlier video, so check that out if you want more detail. Then, when he lifts up his arm right here, this is where they say that's him aiming the rifle. However, do you remember right here how it showed his elbow bent and his support hand up front? Take a look at something.
Sorry. Okay.
Yeah, what I want to point out here that no one's talking about is that he literally goes from putting down the fire extinguisher to a tenth of a second later that he's aiming at the Zeminskis. No human can move that fast. Only is still. That's why it makes absolutely no sense. He's literally
Kyle
putting
Rittenhouse
down.
is Jason Bourne. Didn't you know?
No, what I'm saying is it makes literally zero sense when you watch it at that speed. How it is that it's only that's how it has to be, just like a picture thing. Because if you look at it in real time, you see that his natural motion, how fast any human could move. There's no way he could have gotten his hand down from like leaning down like that to raising up his gun in the exact opposite direction in under a quarter of a second. No human can move that fast. And that's
Kyle is Tom Cruise in Collateral with a hip shot man. Yeah.
I was really surprised at just how much slowed down video is being allowed, because whenever you're talking about a self-defense case, slow down video is always bad for that case, because it makes it seem like why didn't you walk away? You had 20 minutes to think about this because we played it.
Or the prosecution's question to Kyle, like, well, why didn't you try to take away? You didn't try to take away Groskowitz's gun.
That would have been hard. I was on my ass on the ground, and he was, not right next to me. So that'd be difficult.
Go back 15 seconds in this video, and then you got to play it to the end where you'll see the thing about the car. But go back 15 seconds, and you'll see how it's impossible for a human to possibly move the way they're describing him moving. See, there, he's putting it down.
Yeah, let me go back just a little bit further.
And a tenth of a second later.
There's something else that's very important that you're going to want to notice here. You see him run up, drop the fire extinguisher. Runs up, drops the fire extinguisher. I did this in my earlier video, so check that out if you want more detail. Then, when he lifts up his arm right here, this is where they say that's...
How could he have gotten his hand up that fast? It makes absolutely no sense.
Yeah.
While grabbing a gun.
I don't think it's possible. I think this is a visual artifact. I think that they're I'd go a step further, that I think it's improper that they're trying to bring this, I mean, I don't know about U.S. rules, but I've talked to several, and they're Crown prosecutors here in Canada, because that's a whole other thing as to why they're Crown, but they're sort of going like, if I tried to pull this, I would have the chief Crown or chief prosecutor in my office when I got back, going, "Hi, we need to talk about your continued employment here." Like,
well, let's finish the video just because it's almost done. It's almost done. Yeah, this is really good.
However, do you remember right here how it showed his elbow bent and his support hand up front? Take a look at something. Why, as he's running up and drops the fire extinguisher, let me grab another screenshot and show you. Why is his support hand already there holding up the rifle? That's part of the vehicle. That is not his support hand. That is not Kyle holding up the front of the rifle, as would appear in this, as would appear in this.
Oh my
this
God.
white dot is part of the vehicle and is not Kyle's support hand, and it is not him holding up the rifle.
That was my point about it being
it's the car mirror. Yeah, it's the car mirror.
The scary thing here is that I don't know who this guy is. I don't know if he's a technical expert or whatever.
He's blowing up on Twitter now. Pozo shared this out, and he's blowing up on Twitter.
He deserves to be.
So, and rightfully so.
But I mean,
I'll retweet it right now so people can see it for themselves if they want to see it again.
This is not something that it really takes a technical expert to do. It takes somebody who, and he may or may not be one, I don't know the guy, but it takes somebody sitting there and spending the time on it. And like Shirafisi or Richards could have done this same assessment. Why haven't they? Like, why was this not said to the judge and said, "Hey, listen, this is supposed to be his hand. What is this?"
Not that they themselves, because let's face it. When you're on trial, you're going crazy with 1,000 things. You can't be spending the time on this. But someone in their staff should have been breaking down this video and basically pointing this out to them.
Well, to be fair, this is the crux of the trial here, right? This one piece of evidence could sink your client. So I would think we would need to spend a lot of time to disprove this, especially since the whole case is dependent on it now.
I mean, I've never run a case with a $600,000 budget. It just but if I was, I could guarantee you I would have had a team of people, video experts sitting there and I would have said, like, I need to know everything there is to know, every single bit of everything that you can get from this, and tell me what the bill is, because we got a budget for this. Like, this is important.
It's actually $2.6 million when you consider the amount that's for bail that they could pay.
But here's here's a thought. I mean, they can. Oh wait, are they not allowed to play video evidence during the closing argument? Wasn't that a thing, or did I dream that up?
No, they said that they couldn't use footage of the witness's testimony from like court TV, so they can't use that kind of video. But they can use the evidence that's submitted at trial.
I think
I was going to say that's nuts.
They can, but it's interesting because if the jury wants to review it, they have to bring it into their presence, which I'm not sold on this entire concept, but okay. But the defense can make all these statements, right? During close, there's nothing stopping the defense from making that exact same analysis. Do you think Richards will make that analysis? I don't.
I'm hoping Sheriff Feasy's the one that's doing the closing, and I'm hoping that he plays that video
if Sheriff Feasy please, Sheriff Feasy, please, I don't know, knock out Richards, poison Richards, I don't know.
Hey, let's not suggest any crimes here. Just invite Richards.
Good point.
Well, here's a fun one. Would Sheriff Feasy poisoning Richards be qualified as self-defense because he's trying to save Kyle's life? I don't know about that one. There is an imminent threat. I don't know.
So John Cook wants to know if it's a good faith obligation of the prosecution. Is good faith an obligation of the prosecution? I thought it was a scintilla of truth. I mean, you're supposed to. You're supposed to, of course.
The prosecution has long since passed the pushing the envelope of the ethical boundaries here, in my view.
And that's one of the reasons why Emily D. Baker is like super pissed about the prosecutors in this case, because she's a former prosecutor, and I mean, it makes all prosecutors look really bad, and I agree. Are they going to send him to jail for life based on a Rorschach test?
That is the idea, yes.
I hope not, but that's
Can we find this other video from this other guy that people keep recommending
I
the Jack
don't.
Prosecutorial or whatever his name is? Because people keep saying, "Oh, that's really good too."
I don't have that one, but if somebody wants to send it to me,
I don't have it.
This whole video evidence thing is BS though, and essentially the only thing they have with this thing is just one still shot. So hopefully, if the defense was smart, they would raise hell on Monday to get it out, and if it does go, then you raise your objections and hopefully on appeal. If he does get convicted, I think you have a hell of an appeal. Like, look at this still shot, really. So
I mean, if I was defense and they just hired me today to say, come help, come help us out. The first thing I'd be doing walking in would be to say, listen, I want to reopen the objection to the provocation instruction. And here's why. Let's walk you through this video again. We had 0 seconds to respond to this. We have now had some chance to look at it. You got to see this. Let's take you through it. And judge, you've got to understand, 20 hours. I would have been calling experts to say and I would be doing things like take that still frame. And because I actually played around with this, I should actually see if I can pull it up. But I took just a letter R and I typed it out in 4-point font. So it's just barely visible as an R. And then I expanded it using different interpolation methods. And each of these R's is visually distinct from each other. They have different artifacting. They have different patterns to it. And some of them you can see cross shapes that have come up that don't exist in the original. They're pure, and say to the judge, listen, this is what it means when we have these different algorithms. Do these shapes exist in the original? No, they don't. They exist only because of how we've chosen to expand it. And so given that, what we're talking about here is a visual artifact. We know they spent 20 hours doing this. They tried a variety of algorithms and they say, this is the best one. Well, it's the best one because it's artificial. It's fake.
Spent 20 hours and still couldn't say it's a fair, under oath, that's a fair and accurate depiction.
Well, and you get people online saying, oh, well, it's just Zoom. Zoom is common. And I got into a discussion with somebody on my Facebook page who's probably going to be annoyed. I'm not going to call him out by name, but he said, listen, it's no different than if you took a magnifying glass and then you also blurred it. And I was just thinking, if you actually told a court like you said in court, listen, I want the jury to see this, but I want them to look through it with a magnifying glass and also this other lens that will blur it. When you said magnifying glass, the judge would be like, okay, that's cool. No problem. But when you said, I also want to use this other lens to blur it up because otherwise you can't see it unless we blur it, the judge would be going full yell the same way he was at Binger before. He'd be going, you want to blur this? I mean, if you said, hey, I want to apply a blur filter to the photo, they'd be like, no.
You want fewer details?
Well,
that's what you're saying?
It's one of these things that a lot of the public is seeing and thinks is just an ordinary thing, but doesn't understand the disconnect between what you might do if you're looking at your kids' birthday photos from 6 years ago versus what you might do in court, and how important in court it is that we don't fudge the evidence in this kind of way. I really feel like the defense has dropped the ball here.
Aren't you astonished that Schroeder could start that whole thing off saying, hey, I tried enhancing my phone and I saw it looked worse and that it's just blurrier. And then and he starts off with everything in the side of the defense. And then in the end, he's like, yeah, okay, let's just let it in. Provocation. And that's good provocation. What? It's like, did you take an insane pill in the middle of your whole thing? How do you come to saying it's blurry? And I don't see how provocation saying you know what, let's let it in. I'm going to give you the provocation charge based on this picture. There's no logic. There's just no logic at all to what he was saying.
I mean, if I'm the judge there, here's sort of my thinking on how I look at that is listen, I'm looking at my own phone. I'm not a tech guy, but neither is the guy you brought in. Mm-hmm. And this is your evidence. You want to say that this enhanced or altered video is somehow an accurate reflection. In fact, that it's a better reflection than the original. Bring me an expert who actually knows what he's talking about. Bring me an expert who can speak coherently about what exactly this algorithm does, how it works, and how we know it's any good. And if you can't do that, then you only get to rely on the original video. You do not get to rely on any sort of enhancement or the like. It's bizarre to me that they've been able to sneak this in with this expert who's like, how does this work? You'd have to ask the people who write it. It's like, this isn't an expert. This is a user of the software.
Yeah. Here's that. So somebody sent a link to the other video. Do you guys want to watch it?
Yes, please.
Yes. It's another like 2 minutes. So, okay, let's, I should have queued it up before I mentioned it. Sorry, guys. All right. Okay, here we go.
Unprofessional.
Okay, so this is also from Darth Crypto. Here is one more video. Kyle Rittenhouse appears to have been walking back as he was approached by an armed Zeminski. Judge Schroeder asked if you could see Zeminski's gun earlier. You certainly can here. With the FLIR footage as well. There's no evidence Kyle rose his rifles. Let's watch this.
A couple things you're going to want to notice here. If I zoom in over on the right of this image, you're going to see all the way on the right, that's Joseph Rosenbaum doing his Superman impression with his little cape. And that is Kyle Rittenhouse in the green shirt running with the rifle. Now, look up here. As the camera pans around, you're going to notice something. The first shot you have of Kyle, he's standing there, but he's backing up slightly. His left arm is loose, swinging. Now, if I take a picture of this, you'll notice another interesting detail. As Joshua Zeminski is walking towards him, he has a pistol in his right hand. This.
Oh no! What's going on here?
Oh no!
Twitter fails us.
Buffering.
I know. Thinking. Oh come on, man!
It's probably that
When
it's
it got
got
to the
your
good part,
bandwidth
too.
dedicated to this.
Oh, it could be.
Twitter doesn't want us to know the truth.
I know, right?
Maybe make it full screen. Make it full screen and take us off. Maybe that'll help because it'll be less of your bandwidth being used up on sharing.
Oh, okay.
The thought.
Yeah, let's try that. Okay, let's
better?
try that. No.
Nope.
Reload the page.
Dang
Maybe
it.
that'll help. I
Reload
don't know.
Yeah, I guess so. We're 31
We tried turning it
seconds in.
off and turning it back on.
I know, right?
Hello, did you?
Simple stuff. Okay, here we go. Here we go. Cue it up to 30. Okay, here we go. No. Okay. Well,
Oh well.
Well,
really...
I shared the link in the chat, so you guys can check it out. I'm going to retweet this also. But I will take a look at it. If we don't have a chance to look at this now, I will take a look at this later for sure. So, but let me get a couple more super chats too. Big Dog wants to know if we would get Dawn Florio on our panel. So if you're talking about Nick's panel, that is up to Nick. But I'm not familiar, but I looked up Dawn Florio. It looks like they're a criminal defense attorney. So I think that would be very interesting take to get that. Can Kyle sue CNN and company and win? So I know we talked about this a little bit before about defamation. I think everybody kind of agreed probably not because we're talking about claims that are related to actual charges that were filed, which is a distinction between this case and the Nick Sandmann case, because that was just straight up claims that were made that were swirled around. Nobody looked into them. Nobody, so the fact that there are criminal charges connected to it, probably not. I think you guys want to add anything to that?
No, this is a matter of public concern, which means you're at the elevated standard of malice, which means you either have to know for a fact it's false or recklessly disregard the truth. And I think there's enough information, especially from the prosecutor, you can just kind of rely on that for no other reason. So I don't see any viable defamation suit that's possible. No.
Yeah, I think so.
Yeah, especially with the prosecutor literally saying those false statements in his opening. Like you can just rely on that all day, right?
Yeah, exactly. Scott Cardinal wants to know, is the judge able to call for a mistrial because he received those threatening emails? How about if jurors received similar threats?
Yes, it would be manifest necessity but that would just be a mistrial without prejudice. So yeah, if the judge had to recuse themselves, it's manifest necessity, so it's a do-over.
Yeah. So, well, do you guys want to? Here's one more before we change the subject. Is Binger a genius, or is the photo a way to pick off a couple jurors to get a mistrial? Richards will not be able to refute this effectively and close. What do you guys think?
Binger is not a genius. No.
I do think that they're trying to. It's weird because usually the opposite way around, but I do think the prosecution is just trying to get one or two jurors to say he's guilty just to keep it alive, because you get the second bite at the apple. But that's what they're looking for. I don't think the prosecution is in any way thinking they won this case. I think they're just trying to get a mistrial.
Now, do you think that if they do get the second bite at the apple, that they're going to bring it back? Because, like, Kreutz is not going to get better in round 2. In fact, if you got Kreutz back up on the stand today, he's even worse, because he's already given the CNN interview where, and I don't know, I haven't seen the Good Morning America one, but on CNN, he's sitting there saying, I didn't actually have my gun pointed down. He shot me when my arms were up, and that it was impossible for me to sustain this injury in this way. It's like, dude, you just admitted to the one thing under oath. Now you're on CNN the next day contradicting yourself, and then he'd be back in court a third time to say under oath a different version than what he said under oath last time. All you do running this trial again is get Kreutz on perjury. So,
you're already there.
Yeah.
I mean, I don't think you need that.
Well, I mean, it's even better if you've got 2 statements under oath that are directly contradictory, and where he says, well, I was telling you something false under oath the last time. I mean, that just makes the charge real easy at that point.
Yeah. So the support hand theory, Mandy Fabani, that was the videos that we were just showing for that. Yeah. So let's switch gears for a little bit and talk about the Ahmaud Arbery case, because I know it's been like we've been here for almost 2 hours and we haven't even talked about Ahmaud Arbery. That's a trial that's going on at the same time, by the way. So Nate, you've been covering this, and you said that there have been some fireworks in that case too. So I think, right?
Yeah, it's all right. So for everybody, the Ahmaud Arbery case, the theory, I like to just first start with the theories of both sides. The prosecution's theory of the case is simple. Ahmaud Arbery was a black man in a white neighborhood, jogging innocently. He had been looking at the house a couple of times. There had been many people who frequented this house, kids, white couples, everything. But for some reason, Ahmaud Arbery being black, these 2 white racists who happened to live next door saw him running down the street. Someone pointed at him and they chased him for no apparent reason, because obviously he's just a neighborhood jogger. They chased him down, tried to commit an illegal citizen's arrest, but really they're saying that it's false imprisonment. And during the course of this false imprisonment, they killed him. They admitted that they pointed guns at Arbery and he didn't stop. He tried to evade them, and then eventually there was a confrontation where he died. So the prosecution is saying that because they were trying to commit a false imprisonment, and that false imprisonment, that false imprisonment led to his and the felony false imprisonment led to his death, then i.e. felony murder, and everybody there is now implicated in the felony murder. So that's the prosecution side.
Oh, you went.
That's my wife. That's my wife to stop speaking. So then for the on the defense side, the defense is arguing that that he wasn't a jogger, that he was a prowler, that he had this neighborhood under terror for all this time, and obviously they were trying to conduct a citizen's arrest of somebody who was a burglary suspect, and they believed that he may be armed, and when he resisted the arrest, that's when they had did what they had to do, right? They're claiming self-defense. They were legally justified in trying to arrest him, and his resistance to that arrest and then him lunging for their gun gave them a viable self-defense claim. Now, at the beginning of the trial, the owner of the house, he made some statements. He went on Chris Cuomo's made these statements, and he made these statements to the prosecution and on direct examination. He said that Ahmaud Arbery wasn't a problem. They knew he came by all the time. He had never stolen anything. Nobody was really worried about him, and he didn't know why these guys were chasing him down and doing all this. So that was the owner of the house, and that's what the prosecution built a lot of their case on. The fact that the owner of the house said that he wasn't a problem and he wasn't worried about him. Then cross-examination happened, and that story went to shit. The owner had multiple, dozens of 911 calls specifically about Arbery, dozens of 911 calls about all of this. No evidence that he was ever jogging. I'm talking about it was a literal shit show. They even got the guy to admit that he asked neighbors that if they saw Arbery in his home, that he wanted him detained so the police can come. Then the big bombshell came after that, right? After he was broken down, he was totally dismantled. Then they had the cop. Now there was a cop that was investigating these burglaries or alleged burglaries for about 4 or 5 months before the Arbery killing. It was so bad that this cop was going around door to door with Arbery's picture from the surveillance cameras, asking everybody, hey, have you seen this guy? We're trying to catch this guy. We believe this guy stole, is burglarizing the house. He's been caught on this camera, been caught on that camera, and so forth.
Wow.
And so forth. Then one day, about 10 days before, this is again with this cop, the lead detective was saying, the 10 days before, 12 days before Arbery was killed, the owner of the house, the one that said Arbery was never a problem, had called the police, had called the neighbors and said, hey, I got, he's on camera, he's in the house, go get him, go stop him. So the police showed up, and the police 911 dispatcher said, hey, we believe he may be armed. So at that time, police then armed themselves, and the McMichaels, who were also there, the police said, hey, you guys should arm yourself too, and they were armed. And then some of the other neighbors who also joined this little posse in the middle of the night, they also were armed, and then they went on a search for Ahmaud Arbery at that time, believing that he may be armed. The search found nothing, but at the end of the day, it was like, well, hold on, just in case you see this guy, be careful, because number one, we think he may be armed, and number two, we're looking at him for burglary. He may be committing these burglaries. The day in question, they had a little buddy system, which the owner of the house that Arbery kept frequenting into, they had a buddy system where the owner of the house would call. He had the surveillance system up where if somebody would it was a proximity alert where when somebody goes in, the cameras turn on, and then he was 2 hours away, so he would call his neighbor and say, hey, he's there, go to the house and stop him. So that was the system they had. Somebody happened to see Arbery go into the house. They called the non-emergency number. The McMichaels never saw Arbery actually go into the house, but everybody was waiting for him to come back because that was what they were doing. We were trying to catch this guy. He goes into the house. He comes out. Now the McMichaels never see him go in or come out the house. They just see him running down the street. The other neighbor, who was part of this like community watch thing, is pointing. There he goes. There he goes. Get him. Get him. Get him. That's what sparked them to go and chase Arbery, because remember, they had this previous plan with the police and with everybody saying, hey, if we see this guy, we're going to try to detain him for police. We're going to try to arrest him. And then essentially what happened. So right now, the jury has found out that they were canvassing the area for Arbery. The police were actively looking for Arbery. They wanted to make sure, and that this neighborhood was being terrorized by this person. One of the key things that happened, I think last week, the last day, was that the officer who was investigating all this, the prosecutor said, well, after Mr. Arbery came out the house and he started jogging, the defense attorney said, no, objection. There's no evidence that this guy has that he ever was a jogger, that he was jogging. We don't have any evidence. And the judge sustained that objection because there was no evidence that Arbery was actually a jogger. So that's kind of where we left off now, where it's like, the Arbery case, it's still, you still have this issue of whether their citizen's arrest was lawful, because you have to kind of see or have some evidence that they committed a burglary. But the defense's new theory of the case is when it comes to felonies like burglary or even murder, if I see you kill somebody on Monday and then I see you on Wednesday, I can still effectuate a citizen's arrest for that murder, right? It's not like you have to see you, you have to get you at that particular time. Where if it's something like shoplifting, if you shoplift on Monday, then if I don't catch you, then I can't catch you 5 days later and say, because it's not that serious of a crime. So unfortunately, right now, the Arbery case has just taken a turn for the worse, because I think the state was trying to make Arbery into something he was not. For instance, the homeowner was asked about, because he was trying to make it seem like Arbery was not a big deal. So he was like, were you ever concerned about Mr. Arbery? He was like, no, never. He was like, so you're not concerned about a guy in the middle of the winter with no shirt on in the middle of your house, right? At night. You were not concerned. And obviously he had to say, yeah, he was concerned. That was the reason why he was calling. That was the reason they have the text message and everything. They were like, you were concerned. And so he had to finally admit he was concerned. So right now, Arbery has been painted into this maniac who is going around, running around, and all this other stuff. The last part I want to mention is that the racial part of it. Yes, it's true. The McMichaels did use the N-word multiple times after killing Arbery and I think during the chase. But they haven't been able to tie it into their intent because the intent seems to be to stop a burglar. But a burglar happened to be, so these guys could be racist and was like, hey, we're going to stop this black. But their initial response to him and everything was not because it was just some random black guy. It was because of this black guy who even police were looking for the past 6 months. So that's the facts we had. I know that was a little long. Sorry.
That was great. That was a great breakdown. Is there you have any theory as to why the homeowner would have been gone from a position of asking them to help him corral Arbery to turning states against them and claiming that Arbery was never a threat? Like homeowner is very hard to figure out.
The homeowner said that after the time the defense attorney got this out, he said after the event, people started calling him. They started trying to harass him and everything. And he said he was starting to get scared for his safety because he was like, I just own the home. So people were like, well, why are you calling? You see a black guy in your house? Why are you calling? So his story became a lot less aggressive toward Arbery. Like, hey, we're trying to catch this guy because we thought he was a burglar. To well, he was really never a problem. But the one thing that killed the homeowner is that the prosecution in their opening statement specifically said that the homeowner said Arbery had never took anything, and that he believed there was a white couple who was caught on screen and took something. During cross-examination, they pulled out a transcript of a 911 call the homeowner made, where he specifically said it was not the white couple, and he didn't believe it was the white couple. He believed it was somebody else. So he was caught up in a lot of lies and misstatements, but I believe it was because he was intimidated of, he didn't want people to protest in front of his house again. And this guy, just to let everyone know, the homeowner is, he's critically ill. So he's looking for a heart transplant now. So this guy is on his last legs, and he was building his house as, like hell, I'm about to die. So I want to build this house on the lake and die in this house. So that was the reason why he was building this house. So he just wanted peace and quiet. And I think this is the way he thought it was best to be peace and quiet.
Well, I got some sympathy for that, but I mean, it
sounds like the way you describe it sounds like a bunch of racists who may really not be guilty.
I mean, that's the thing is
so it makes him a very non-sympathetic, sort of figure that you so the lawyer. I'm sorry, I keep cutting you off, Ian, every time you.
Oh, no worries. We've got a delay, so that's what does it.
But to me, they just painted as being like these guys are probably racists, but that doesn't mean that they're guilty of murder here. That under the law that existed at the time that this incident unfolded, that they were culpable of committing murder. And this is such an ugly case to handle.
I mean, there's so much.
A lot of twists and turns.
That's pretty much what criminal law is usually about. Is you may have a client who is a terrible person, but may not have done this particular thing. And it's not necessarily that serious, but this is why we don't allow character evidence. Character evidence, for the people who aren't sort of familiar, is just basically saying this guy is a bad dude, therefore he must be guilty. And there's actually a history to that, because what they used to do is, if you had a murder and you didn't have a suspect for it, you'd drag in a guy and you'd say, he was convicted of aggravated assault on this day. He was convicted of burglary on this day. And you could get them to convict for anything, even if there was no other evidence. Because if you've got somebody who's a bad dude, it's real easy to say, well, okay, he probably did this. But, you end up dealing with all of these things where, you get files where it's like, this guy happened to be in the area and he's got a long record for thefts. So the police say he must have committed this theft. And you end up looking into it and you're like, no, he didn't. It turns out some other guy did. Or it turns out we just don't know who did. Just because somebody's a bad person, you can't necessarily assume that they're guilty. Even bad people have self-defense arguments. We see that, I covered a video a case on my channel where a guy who was driving around dealing drugs, one of his rivals tried to kill him. So he pulls out a gun and shoots that guy. He was acquitted. It's hard for people when they're looking at these cases to separate those two things, especially when the racism and the event actually happen at the same time. But it also ties into something I warn people about, because I get people asking me all the time about citizens arrests. When can I do a citizen's arrest? What? And on a citizen's arrest, you better be right. You better be clearly right. And, if this guy had been walking, with, a saw or something that he'd stolen from the site, the accused in this file would be in a much happier situation in terms of their argument on, we were conducting an arrest and then we had to defend ourselves. It can be really expensive to citizens arrest.
See, the argument here is in the burglary aspect is obviously the linchpin to this. The argument is that you don't have to actually see the person stealing something, but you have to kind of prove that they have the intent to steal. So what the defense is doing, the defense is actually trying to prove his intent by saying the guy's been in the house X amount of times. Something was stolen from the house. Why would you keep going back to a house that you're not even yours? He wasn't jogging, right? Why would somebody who's not jogging in this neighborhood continue to go back to this particular house, look around, look through stuff? What is their intent to be there, right? Because now there's no evidence he was jogging. So it's kind of walking the jury into the position where, why, if he's mental, and remember his mental illness issues aren't even in front of the jury either. So if all of that is coming into play and you're saying, the jury's, even though it's not the prosecution doesn't have to prove it or show it, the question to the jury is going to be, well, what the hell was he doing? If he wasn't jogging and he wasn't doing this, what the hell is he doing here 12 o'clock at night, 10 o'clock at night, 9 o'clock, all these times at night, looking through stuff? If he's, what was his intent? And I think they're walking people down the path that his intent was to steal. And if his intent was to steal, they've already gotten a record that this was, even though the house was under construction, it was a dwelling. And if you steal something or have the intent to steal from a dwelling, you're committing a burglary. That's where they're going to. And if that's the case, then even if that intent to steal doesn't just go away, when he's running out that house and people are saying he's running out that house, that could technically give you enough to say we could reasonably assume that he committed burglary. But now I think the key for the defendants, the issue that the defendants are going to have to walk over, is that they weren't sure that the guy who was running the day he was killed was the same guy on those tapes. They said he fit the description. So that now is the balancing act for the prosecution. You can't just chase any. Was it any black guy good enough? Because I'm assuming that's going to come with any black guy, right? You just said you saw a black guy and you believe that was the black guy. But how do you know? And they admittedly said we didn't know that black guy who was running was the same black guy on the tapes. So obviously, there's a lot of twists and turns to this.
So because as I understood it, they didn't see him go into the house the day of. They didn't see him come out of the house the day of. They didn't see him initially run away from the house the day of.
Correct.
Their first exposure to him was at some point later in the day. So they can't use that he was committing a burglary on the day of because they have no knowledge to draw those conclusions, correct?
Correct.
So they're trying to say we have knowledge of burglary from prior days. Okay. So assuming that's true and assuming that they could positively identify him, which I understand is not correct, but assuming those things.
They could not.
But assuming they could, would that give them a sufficient basis to conduct a citizen's arrest on that day? Because it's not in their immediate knowledge or their immediate presence, right? So I'm having a little bit trouble even assuming that they were able to positively identify a guy. I'm having trouble seeing how that gets you to citizen's arrest, or am I missing something?
No, well, there are two parts to the statute that they explained. The first part of the statute is it has to occur in your presence, right? But the second part is if somebody's escaping, right? So you don't have to witness it, but the escape piece, and the escape piece is actually escaping at the scene. So in this instance,
am I wrong about escaping? Have I been wrong about escaping this whole time?
You have been wrong about escaping. What they are saying is that the fact that somebody saw him come out the house and says he's gone, that's him. And if they can prove that situation, that he was going inside there with the intent to steal, right? They didn't have to, but the fact that you can show that it was reasonable to believe that's a burglary, then they got him because they were trying to stop someone escaping from a burglary. But the police, just to be fair to both sides, the police officer, the detective who was investigating all this, said that the reason why they were canvassing for Arbery for about 2 months was that the way it works is that they couldn't even get him on trespass because the way the trespass laws work in Georgia is that you must first warn the person that they are not authorized to be on private property. So you have to have either a sign or something, which they didn't have. So what they were planning to do is to actually catch Arbery on the property, give him a formal trespass notice, and then if he came back to the property, they could arrest him for trespass. But the defense countered that by saying, but if you can prove someone intends to steal from a dwelling, that's a burglary, right? You don't need to do all that for the trespass. So those 2 points have been conceded. So, was it a simple trespass, which they couldn't arrest them for, or was it a burglary? That's the decision that the jury has to make. And that's actually been an opening statement. The judge charged the jury saying, hey, you were going to have to consider whether this was a burglary or not too.
So is there anywhere in the video, and maybe you don't know exactly where, but is there anywhere in the videos of the trial where they discuss this aspect of escape and whether or not that qualifies as escape? Because
or is it opening statements? Go into opening statements, and the defense attorney goes into the escape issue and the opening, and the judge goes into the law, but then he reiterates it, saying, "Hey, this is the second part of the thing, and this is how it actually works." Even though don't forget, the lawyers can't give the law, but they gave a summation of the law.
No,
and
this is
running from this.
This is a big deal for me though, because if I really got this wrong, then I'm going to question everything I ever believed, because
your definition of escape is how it is here in New York. Escape is escape from either an officer when officers arrest you, or from judicial, or if you're being put in, if a judicial officer has sentenced you to any time in jail or in prison, and you can escape from that. But you can't just escape from people, regular people on the street. So your escape. Your definition of escape is right in New York, but in Georgia,
but I looked at every single decision in Georgia specifically and tried to do I don't know that I've done a deeper legal analysis maybe ever. So if I screwed this up in Georgia, man, I don't even know. We're
gonna have to question. We're gonna have to have a revote on the whole part of the LawTube team thing here.
No, I mean it's a big deal if I fuck that up. Yeah. It really is.
Okay, I'm just saying.
Yeah,
I think you're being hard on yourself. I saw how you went through every case in Georgia. I saw how you broke that down. So I think you're being very hard on yourself here. So, and that's why I was making light of it.
No, I mean that this is this. I appreciate you trying to make light of it, but it's a big deal for me, because I had this one, I'd call him troll, but apparently he was right the entire time, and I must have made 2 or 3 or 4 videos specifically addressing this exact issue of escape. I did one of the most thorough deep dives I've looked at ever, trying to analyze this issue in every case I could find in Georgia, up to and including like the committee notes and everything, and like. So if I somehow fuck that up, I don't even know, man. It makes I feel like a really shit lawyer right now if I fuck that one up.
Is there a citation that says that you got the law wrong?
I don't know. That's why I was asking Nate if it's on the record. So if I screwed that up, man, I feel like a real shit lawyer right now, man. Damn.
Hey, no, we always. I mean, everyone gets something wrong from time to time. Yeah. But I will. Maybe this will. I don't know. This will interest people. We got a super chat from Darth Crypto. He says, "You guys watching my videos? Wow. There's more where those came from. I'm gonna settle reasonable doubt today, definitively. So, you guys, be sure to go and check out his Twitter handle, or Twitter account. I don't know. What are words, guys? I'm like more boomerish about social media than I think anyone. It seems like. But yeah, go check him out on Twitter." And take a look at more of his videos.
Yeah, Darth, I got give you kudos. You've been doing phenomenal work. Yeah. And all the viral, I hope you get even more. There's even more virality to what you're doing, because you know what, it could have social significance, especially if it actually sinks into the very thick skulls of his defense team. So hopefully, with everyone share with the great work you've done, and I will continue sharing it. And I'll urge each of you in the chat here, just follow Darth Crypto, find his vids, and just retweet it, make it go viral all over again. Yeah. That you have more social significance. You, the individual person in the chat, have far more social significance than you could ever fully appreciate it. And you say, like, this is a must see. and Kyle's defense team must see this, something to that effect, and just keep retweeting, because tomorrow is the day. I mean, if they get this 3 days from now, it's useless. Basically, we have 18 hours for them to actually adjust their approach in court based on the video work that Darth Crypto has done. So I tip my cap to you, Darth Crypto.
Yeah.
I've already tipped it privately. I'll tip it publicly, and thank you for your work, and urge each of you in the chat to find this stuff and just retweet it. I think Legalbytes has been retweeting. You can just retweet Legalbytes. Just get it out there. Get it out there more.
Yeah, for sure. And I mean, unfortunately, obviously the jury shouldn't see any of this, right? The jury should not see any of these tweets or any of these videos because that would be highly, highly improper. But whether the defense team will, I know we've gotten some questions about whether or not we have any way of contacting the defense team. I know that I don't know about you guys, but I don't have any of their contact information, and probably I don't think that they are looking to be contacted by anybody else right now either, because they have so much going on with the trial and trying to finish it up, trying to wrap it up, put all the pieces together for closing arguments. I personally wouldn't want to interfere, because even though, we have our opinions about how trial has gone, there's also a lot that can be missed by too many people interfering with the case. So too many cooks in the kitchen, so to speak. Anyway,
I suspect that their email is just not getting checked at all right now, just because of how many people are probably sending them messages. The vast majority of which will just be annoying garbage.
Stuck.
Yeah. And so, I mean, what they've probably got right now is an assistant who's basically skimming through everything going, is something literally on fire? Like, am I supposed to be in a trial somewhere that I'm missing? Otherwise, either delete it or, put it for later review. There's no way. I don't know how I'd get in touch with them right now, because if I sent them an email, I'd expect it to just sit in the please go away for now box.
Yeah. Let me get a couple more super chats because I'm way behind on these. Let's see. Why do you guys think they didn't decide to do a trial by judge? And do you think that would have been a better choice? What do you guys think? Isn't it that the prosecution gets a veto in their area?
In some states they do.
I thought this is one of them, but I could be wrong about that.
That might be true.
Also, self-defense, in my experience, is something you typically want to put in front of a jury, but I don't know if this is the case. I suspect that Binger might have been the guy to insist on a judge.
Okay. Yeah.
Then again, I mean, it's hard to say why anything was done in this trial, because so many of the decisions make no sense.
Yeah, if Richard screwed up the strategy here, that would be shocking to everyone here. So it must not be his fault at all, because he's been spot on from day one.
So let's see here. During closing, Mr. Tibbs89 said, during closing, should not the defense show Hammer submitted videos of the same provocation moment from the other angles to disprove this blurry evidence? They would want to be showing videos from that same provocation of, from other angles that they have videos of that have been introduced as evidence, or just talking about the people that were there and testified right in front of them, because that's the whole point of putting a witness up on the stand is that the jury can actually look at their demeanor, determine whether or not they are lying or whether they're telling the truth, and whether or not they accurately remember their the events that happened. So Nate, you want to share something?
Yeah, I'm sharing this. This is the defense attorneys for the Arbery, and this is him explaining it. So this is what the law supposedly in Georgia is.
Okay.
So I because I felt bad, so I'm just want to make sure I'm not misquoting it for uncivil here. I don't know if you guys. I'm gonna play it.
I can tell you about. The second sentence is, if the offense is a felony and the offender is escaping or attempting to escape, a private person may arrest him upon reasonable and probable grounds of suspicion. That's why Travis McMichael and Greg McMichael sought to detain Ahmaud Arbery. There was no crime committed in their presence. We're not contending there was a crime committed in their presence, but there was probable cause to believe a felony had been committed and that this man was attempting to escape or flee. That's why citizen's arrest is in this case.
Does that close the case? Is that case closed?
Escape or flee. I have problems with this because the statute says escape. So either, flee is not sufficient. If fleeing counts as escape, then so be it. But that's the issue. Does fleeing count as escape? Because it doesn't say flee. It just says escape.
Well, again, this is him giving the opening arguments in court in front of the jury. So I'm assuming if he was like all of that, if this was like totally off, I'm assuming that he can't be just straight up lying to the jury. Because that's his whole case is based on they didn't see it, right? He's saying they didn't see it at all. It didn't happen in their presence. But if they have probable cause that he's escaping after committing a felony, this applies.
I might be very wrong.
But don't beat yourself up about it, though.
Yeah.
I mean, honestly, because everybody gets stuff.
Yeah, I agree with you. I did research. I agreed with you. I thought it was right too. But when I heard them go over it, I was like, oh shit, we've been wrong. Yeah. This is a private party escape, and escape for them is escaping from the person not want to. If a person committed a burglary, and you don't even have to see it, they say you don't even have to see the burglary.
No, I'm not contesting that part about the. I'm not contesting the first half of it about the felon thing. Burglary is a felony. I agree with you on that. So the only question I'm raising is about this escape element. That's the only question I'm raising, and that
changes the McMichaels. Go ahead.
It should, but I don't know if there was a motion to preclude the defense at any point, and if there's papers on the issue, because you can't offer a defense that isn't legally cognizable. So if there is no evidence that would allow for a conclusion of escape, then you wouldn't even be able to offer the defense. So I don't know if there's a motion to preclude or any sort of things on that, because I need to figure out what's going on. So. Because I've been basically putting myself as a subject matter expert on this issue. So this is not just a minor screw up where like I made a mistake on something. This is a pretty serious screw up on my part if I screwed up. So
Laura S, no, they have not done closing arguments yet. That is tomorrow. So be sure to, if you've got time and you've got attention, be sure to go to Nick Rekieta's channel tomorrow. We're going to be on a panel watching the whole thing, commenting, and it's going to be very exciting. We're all very interested.
Oh yeah, it's gonna be great.
Going through some more super chats. Okay,
listen,
our attorneys.
I gotta run it. We've been here for a couple hours, and I got kids and my wife that I gotta take care of. But listen,
totally
thank you guys. Thanks for having me so much. It's great arguing with you guys as always.
Yeah. Thanks for joining us, Nate. And if anybody is not familiar with Nate, he's obviously you can check him out on Nate the Lawyer YouTube. And where else, Nate?
NateTheLawyer.locals.com. I forget. Yeah. And I'm the soccer guy. I'm the soccer expert. So.
Oh, that's why. Of course, the women's soccer.
Yeah, the soccer.
Soccer.
That's awesome.
What?
That's awesome.
Later, guys.
See ya. And you guys, to the rest of the guys, if you have to get going, that's fine too. I obviously have to keep going through these super chats, but I'm not going to take it personally at all if you guys need to get going and do other stuff.
I kind of need to bust out of here also.
Sure.
So I will tell you, if you check out my channel, if you're subscribed, you're unsubscribed. I lost over the last day. I lost 100 subs. If you don't hit the bell, don't bother subscribing. Seriously, don't bother subscribing because in 3 days, I'll tell you right now, in 3 days, you will be cleared off. I'm telling you, she clears off everyone. Susan really, really hates me. So I urge you, if you're interested in my content, subscribe and hit the bell. Notice of all personalized. Otherwise, we're never going to see each other, and our relationship is just gonna fall away. So please make sure. And thank you for having me on Legal Bytes. It's always a privilege to talk with you. You give me a chance to argue with Nate. And uncivil, don't beat yourself up. Make a mea culpa video, and that people will get that much more respect for you. And Ian, I gotta tell you, out of all the great things that happened for me in this trial, seriously, I'm not making a joke at all. Like meeting you, definitely ranked in the top 3.
Absolutely.
Thank you, and likewise, I've really enjoyed talking to you guys. It's because this is the first time I've sort of had much interaction with the rest of LawTube, and it's been an amazing gift.
You're a phenomenal addition to our little community here. So it's great. I look forward to working with you in the future.
Absolutely.
Take care, you all. Thank you so much.
Yeah. See you, Joe. So, all right. Well, if you guys are going to stick around, well, I'll just kind of go through some of these super chats. If you guys are okay with that.
Yeah.
That's fine.
Kurt, are you okay? Don't beat yourself up. I can see you're beating yourself up. Don't do it. That's the whole thing about a fact-oriented analysis is that when you base it on the facts, on the law that you come across, then you're allowed to change your opinion if you come across something that says otherwise.
Yeah, I don't know. I don't know what the equivalent is for you guys, but it would be something that you like think that you know solid, and you're suddenly being questioned on. So I don't know what the rough equivalent would be in your guys' practice, but I thought I had this solid, and that's why I'm beating myself up on this one. I make legal mistakes. I make statements that are usually not that big a deal, but it's like this. Yeah, I'm not trying to be overly dour just for the purpose of getting sympathy or anything like that. It's just like, I'm questioning. Yeah, I don't know what to say about that. I'll just shut up talking now. But thanks for the reencouragement anyway.
I mean, here's the thing. It didn't happen in a trial, so...
Yes. No one's rights were violated by
it. Maybe Richards is the best defense lawyer of all time. I've been wrong all this time. That's
No. So here's a super chat. Are attorneys allowed to watch reports and YouTube outside of the court? Is there any chance crowdsource influences strategy? Yeah, attorneys can look at whatever they want. Whether or not they want to be watching us while trial is going on is another question. I probably wouldn't.
I know for sure I wouldn't. Too many voices in my head.
You would second guess yourself.
Yeah, too many voices in my head. No way.
But I mean, with this budget, I wouldn't be watching anything myself. I might be like, hey, Junior, the junior at the firm, your job is to pay attention to what's going on. Like, see, does the public think we're winning? And just, is there anything? Sometimes it could be worth asking other lawyers, what they think. I've had trials where you take a break, you turn around, you see there's another lawyer that's been sitting there watching you, and you just go, what do you think? And sometimes I've gotten some great advice from other people and some not so great advice. You gotta decide.
Yeah, that's the thing it's kind of like with anything else. You want to know who's the right person to listen to, because if you take advice from just about anybody, you're going to get a lot of junk advice from people that know absolutely nothing about what they're talking about, right? It's the same thing with having a YouTube channel. Like you can get tons of advice from all kinds of people, and that may or may not be good advice depending on on their experiences. So here's another question. What is your background before LawTube? So mostly litigation, a lot of employment litigation, and a lot of wills and trusts, conservatorships, that kind of stuff. Some transactional stuff as well, but mostly litigation, and some business stuff too. Let's see. Gonna get through. Let's pull up another one. Will Kurt be doing a vid on the fire extinguisher?
No. That's a capital rights joke for those of you who are missing the reference. So
someone else said,
do you want me to explain the reference?
Sure, yeah, let's do it.
All right, so this was a whole big thing on my channel where people were just doing it for the memes. But there was the officer who was pulled out of the Capitol, right, who died from causes unrelated, as we learned from the autopsy. And there was a persistent rumor at the time of the event, around the January 6th-ish timeframe, that officer had been hit with a fire extinguisher, and that was part of what caused his harm, that he was bludgeoned with a fire extinguisher. And on my stream, I was talking about other officers who were in fact hit with fire extinguishers. It's like, I have the video. I can show you what it's happening. Like there really are other officers who were hit by fire extinguishers. And then there was confusion. I think legit at start was like, wait a second, you're talking about this officer hit with a fire extinguisher. That was disproven. I'm like, no, I'm not talking about that officer. I'm talking about this officer, right? So there was a point of confusion. It's like, your analysis is wrong. You're an idiot. That guy was never hit with a fire extinguisher. That's like, and I'm saying that's not what I said. So then it became a meme, you know, where it's like, you want to talk about the fire extinguisher some more. And yeah, that's the background of that. So it's just great.
Oh man. Yeah. That's great. That's awesome. So you should really have a fire extinguisher symbol on your on your
Let me tell you how much I just truly love when people start saying things that I said that I didn't say. It's just so much fun for me. This was happening even yesterday in my chat or my comments where people were where I was blackpilling. And it's like, you said Kyle will be convicted. I'm like, I didn't say that. I said the odds were more likely than not, in my opinion, for the reasons I stated, but I didn't say he would be convicted. Please stop saying things I didn't say. It's very annoying.
So here's a question. New to learning about law, what happens with a hung jury? That turns into a mistrial.
Do over.
Yeah, which means that the prosecution can either decide to bring the case again or bring trial again or not. So that can be either good for Kyle or very bad, because if they do a do-over on it and the prosecution actually does bring another one, then they can also kind of fix everything that they did wrong the first time around. But on the other hand, maybe the defense can also do the same.
Some stuff is going to be unfixable, though. I mean, just the whole thing of like Kreutz's testimony, you can't fix it because anything you do to fix it is just going to be contradicting his previous. But it's I don't know. I would say normally that this would be one to just not try again, but I would say it was one to not try in the first place. So
yeah, exactly. Greg Marquez says, if the supposition is that Kyle was trying to kill, why did he not kill Gage? I think because one of the questions I think that they asked Kyle on the stand on cross-examination was something about like you weren't trying to kill him. So they were kind of like suggesting that maybe he shot his arm intentionally. So it wasn't a fatal wound, or he wasn't trying to get him on a fatal wound or something. Did you guys see that? Am I imagining that?
They're trying to use the fact that he says, I was trying to stop the threat, like every lawyer would say. This is definitely what you want to say. That I was trying to stop the threat. Therefore, he was behaving recklessly because he wasn't trying to kill. So he was firing his rifle all willy-nilly. It was sort of the implication. The whole thing doesn't make any sense. But then again, the prosecution, you know, if they're so inclined with a little bit of magic, they might be able to get to where they want to be. Particularly if Richards closes and I lose the will to live again. So that'll be fun. I did like that when Richards was opening and people were like, Uncivil is falling asleep, and I'm like, yeah. You know, my eyes are half closed. It's like, you're falling asleep, you're not paying attention. I'm like, I'm doing my best, guys. I don't know that it's a me problem that I'm falling asleep at this point.
Yeah. So if it is a hung jury, what are the odds of prosecution retrying? I mean, I don't know, because it seems like it's hard to know without getting an inside look at the prosecution, at the DA's analysis, right? Like, how is this going for them overall? But I don't know. What do you guys think? What are the odds?
1 and 1, because it's political.
I was going to say they're extremely high because of the politics. Yeah.
If they were going to drop this because it's a bad case, they would have dropped it the first time. Like, the case isn't getting any better, but it's not getting any worse. It's still garbage, and it's garbage that's that's caught fire. But it's frustrating to watch because their argument for conviction is such sketchy stuff.
Yeah, I totally agree. Let's see. With an AR-15, he could have done it from the dark at long range, macabre as it sounds. I mean, talking about killing Rothkowitz, right?
I don't know about that. Dark is dark. I mean, you still have trouble seeing your target. The AR may be capable of it, but I'm not sure you necessarily are. So that's
true. Do you think Kyle has a meritorious IAC claim?
What's IAC?
Ineffective assistance of counsel.
Oh yes.
Oh,
I think you're heading in that direction. The problem is the standard is very high. It's very high.
Yeah.
I think every bad decision could be argued as a tactical bad decision. And
I agree.
A tactical bad decision that a reasonable lawyer would make, though, it's like, I don't know. Yeah.
If I don't see a motion for a mistrial with prejudice, I think we might be there.
We've had lawyers fall asleep, and that's not been enough, though. So I wouldn't.
Oh yeah.
I wouldn't bank on it. I wouldn't bank on it. It's a tough. It's a tough cookie.
Yeah.
I mean, I'd argue it on appeal if that was this, but I don't know that I'd.
Yeah. Can I make my appellate argument? But seriously, though.
Yeah.
This is yeah.
So is Richard's performance subject to being worried about future cases in this court, not pushing the judge too hard? I don't get that sense. I don't know about you guys. I don't think that there's anything that he's done to even come close to pissing off the judge. So I think that his working relationship with Judge Schroeder seems to be perfectly well intact. Binger, on the other hand, I would be concerned about any future hearings. Although, I mean, since Schroeder yelled at him in court a couple times, like he's also kind of mentioned after the fact, like, hey, today's a new day. We're cool. Everything's fine. Let's move forward. So that, I mean, he seems like the kind of judge that would in future cases maybe still be like, all right, that was the last case.
Yeah, Richards
crazy.
Richards is nowhere even close to being problematic with a judge. It is beyond the horizon. It's like on a different planet in a different solar system somewhere of how close it is. Richards is bad. That is my continuing theory of Richards is bad. It's Hanlon's razor, never put to malice what can be done to incompetence. I've broken that rule once or twice. For example, on the Epstein didn't kill himself meme, because I'm like, that is a lot of incompetence and I'm not really buying it. So I'm going to go with malice on that one. So I break my rule occasionally. But on this one, I'm like, this is just incompetence to levels I didn't think were fully possible. When you, Runkle, and me and Nick are doing things off the top of our heads without even thinking about it that are better than anything the defense has come up with. It is annoying to levels that are impossible to fathom.
I mean, we're not under the same stress. We're not, so that makes it a little easier, but it's frustrating. And the not pushing the judge too hard, if you were going to be worried about that, this would be the case to burn whatever. But
true.
Judges respect pushback. Judges respect that you have to fight for your client. If you're worried about the judge losing respect for you, the way you do it is you sit on your hands on an objection. The way you do it is is that you screw up your case. I had a case where it was a single objection case. It was basically the prosecution was going to be relying on a particular document. I knew that document was inadmissible and they could not win without it. And so I had the flu and it was a terrible day to run a trial, but I had to run it that day because the prosecution was going to find the mistake and fix it if there was an adjournment. But I'm sitting there looking like death and not fighting very hard because I know what I need to fight on. It's that one objection. And the judge was sitting there like losing respect for me as we were going right up until I won it. Now, if I hadn't won that one, I would have had a hard time appearing in front of that judge ever again. That judge would have had a lot of, but when I've pushed back with judges and said like, no, I'm standing on my objection here. So long as you're not screwing up, so long as you're actually, good at your job and you don't burn the judge that way. That's my take.
On this whole Monday morning quarterbacking thing, I just want to say this, okay? There's Monday morning quarterbacking, then there's Monday morning quarterbacking, then there's Monday morning quarterbacking. This would be the third of those versions. Let me illustrate the differences for you. All right, so the first version of Monday morning quarterbacking would be something like, all right, the quarterback threw a pass to a guy who was well covered, and so they intercepted. All right, that seems like a bit of a questionable decision. because of the coverage. Why did you make that particular call? Then there's the version of, okay, it's fourth and long. You have time left on the clock and you're throwing the pass. Why did you make that decision? Seems like a questionable decision. Then there's version 3. Hey, other team, here's the ball. Let me hand you the ball. Would you like me to help you run in the opposite direction as I give you coverage and protect you so that you can score 2? This would be kind of where we are. It's like, I understand that there's Monday morning quarterbacking where we're all yelling at the coach because how could you make that call? But if it had worked out well, we'd all be cheering the coach, right? We'd be saying how brilliant that was. If it all worked out well, but it went bad. So we're pissed, right? There's that. Right. And then there's I'm basically purposefully giving the other side the ball and I've put my team off the field and whatever. So I think we're in version 3 of the Monday morning quarterbacking where nothing makes any sense and it's all stupid.
I may not be a master chef. It might not be that I could cook whatever, but I do know that boiled eggs shouldn't catch fire.
Yeah. Or to quote the one comic who did this for a heckler whose name escapes me. It's like, there's a helicopter in the tree. I don't need to be a helicopter pilot to look at it and be like, guy done fucked up. Yeah. That should not be. It doesn't take expert knowledge. Something went wrong. That it's like, yep, guy fucked up. So that's kind of where we're at.
So here's another question.
Please stop. I don't want to stop though. I want to keep ranting. People don't like my ranting.
Here's another one. Should defense object if prosecution uses the word provocation outside the supposed gun-raising incident?
It'd be real hard. I mean, it depends on how, right? If they're suggesting that the jury should misapply the law, then you have to object, right? If they're saying, his mere presence was a provocation, you got to stand up and be like, no. But if Binger has half of a brain, and I mean, I don't think he's dumb. I think he's not great, but I also think he's kind of sketchy. And so I do think he's got half a brain. I think he can work around that to not do the obviously bad thing, but still put the idea in the jury's head and have them thinking, him putting out fires is a provocation. Him cleaning up graffiti is a provocation. He could be fuzzy about it, and there won't be any way to object to that.
Yeah, I agree. Why do you think defense didn't redirect on Kyle? Honestly, I think that probably because his direct and his cross-examination went on for such a long time, there probably was no way that the jury was going to be able to retain more information. But I don't know. I mean, that's why what I'm thinking their line of reasoning may have been. I don't necessarily agree with the decision not to do a redirect, because I think that they could have asked 1 or 2 questions just to punch in some last points and leave the jury with that. But what do you guys think?
Well, also because, as far as it goes, Kyle's testimony was pretty great. There were problems, and the prosecution can highlight those problems, which is one of the reasons not to put him on the stand. But those problems were predictable in advance, which is also why you don't put him on the stand, because you kind of know that's coming. But all that being considered, he did as well as could be reasonably expected. So the decision not to redirect makes sense to me, because why give the prosecution another chance? At a recross, why not just let it sit?
Fair.
So I think they made the right decision in that particular call.
I mean, there were a couple of things that maybe they could fix up. One of the things is I normally hate redirects, because I think most lawyers, or a lot of lawyers, screw up with redirects, which is basically the other side scores a point, and then you come back and you try to save that point and fail more times than not. And what you've done is you've just pointed out to the judge or the jury, whoever's trying the case, this is where I think they scored a point, and I can't fix it, which is worse than if they just score a point and you just leave it. Either they say, oh, well, that can't have been such a big deal, or maybe they miss it. Maybe the jury doesn't catch that moment, and, you didn't need to shine a spotlight on it. The other thing is, when I think about, more Kyle time is not really what I think that this trial needed. So
that's true.
The longer he's up there, the more chance he says something fatal.
That's very, very true. Here's another question. Should there be any sanctions or charges filed against Kreutz for contradicting his sworn testimony on news shows before the case is decided?
Not for that reason. No, he's free to talk to. He's free to talk about to anyone he wants.
Yeah, so because in theory, at least in theory, the jury isn't watching, right? So there's no harm to the outcome of the case. I mean, in theory, we're assuming that everyone is doing what they're supposed to be doing.
Yeah.
Yeah. But
maybe they're watching us, and hopefully they're like, this. In case there is a juror out there who is watching this for some reason, defying some instructions, I just want to let you know you should definitely be acquitting. These charges don't make any legal sense. So
right.
Yeah.
Here's another one. Other footage shows the raised gun moment. The state says from different angles and better quality. If state has access and didn't disclose, is that a Brady violation? What do you think, Kurt? I mean, because they're supposed to provide any kind of evidence that would diminish culpability, right?
Right. Yeah. So if there's other footage that's not part of the record, which I don't know that's true because there's so much video evidence that's part of the record. So I'm not really sure 100% what we're referring to. But if there is other video evidence that hasn't been disclosed, that could be a Brady violation. The problem, by the way, in case you're thinking ahead to appeal on a Brady violation, is the court first has to say, okay, there's a Brady violation, but then gets to the next step of, does it impact the verdict, right? If you say, okay, that didn't happen, so it should have happened, here's what would have happened, does it change the outcome? And more often than not, it doesn't, because there's so much evidence that would, it's the same thing with like, should that witness not have testified? Should that question not have been asked? So it's like in your mind, you just go, okay, excluding that, is there enough left to sustain the charge? And much more often than not, the answer to that question is yes. So I wouldn't get too excited about a Brady violation.
Right. Yeah, especially because there's so much video evidence in this case.
That too.
Yeah. Can they mention that they didn't call the Zeminskis in closing arguments? Is that something that they can comment on?
I don't. Well, I don't know. You can say that there's this gunshot from this guy, and we didn't hear from them. I'm not sure why you would, but you can I think mention that because it's in the video evidence. There's a guy shot a gun.
Yeah.
This guy didn't testify, so that's factually correct. So I guess.
I mean, I don't know if it ties into your Fifth Amendment sort of aspects to it.
Nick, I'll send you a link.
Yeah, Nick can come along and help us all.
Yeah.
I think
thanks for the super chat, Nick.
Nick was not blackpilling as much as me. He said yesterday on his stream that he still thinks the odds favor Kyle.
I mean, here in Canada, I would absolutely be saying yes. Talk about that guy and why we don't have his evidence, but we don't have the same Fifth Amendment protections. Zeminski would not be able to rely on that because even if his evidence was strongly harmful to his later criminal trial, they'd just say, yeah, you testify, and then we can't use it in your criminal trial.
Yeah, he's not the defendant here, though. So talking about it isn't prejudicial in the same way. So I think you can't. Even then, you can't like go full out and make the point of he has the right to remain silent, and so he must be guilty. You can't do that even for him.
No.
But I think you can get away. You can get away with here's a guy, he fired a gun, we didn't hear from him. And
I think
you draw an inference. I think you can do that.
Well, and I think the other thing you'd want Zeminski for is supposedly the provocation is him pointing a gun at Zeminski. You know who we don't hear say that? Zeminski. Where's Zeminski to say that there's a gun pointed at him?
That's fair.
That's the line I'd want to put to a jury is just to say, if this happened, why aren't we hearing it from the person who is best situated?
That will work. You can do that.
Yeah. Huh. Interesting. Well, I guess Nick is on his way.
You can add in that line to your impromptu close, which was very good. It's good.
I mean, the thing is,
you get all the points. You got it.
If you're actually doing a close, you'd want to spend more time on it than just I started talking and am coming up with ideas as we go.
No, but that as sort of the intro to the close would work. You're highlighting all the points.
I'm just concerned that
providing the outline of the story, and then you can go into more detail about those points. But or you can flush it out and tell it that way. But either way, it's like, yeah, you got an outline that's workable. You're making some sense. I'm liking where this is going. It's almost like you've thought about this or maybe done it before once or twice. I like these guys.
Do you think it's right for the judge to not allow Kyle's social media posts after what happened being right?
Yeah, the posts being excluded are right because it doesn't go to the moment of truth, right? Whether Kyle was a murderer goes to his knowledge base at the time. So anything that happened after that is irrelevant to that. So whether or not he went to a bar with the Proud Boys and blah, 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 whatever, doesn't matter because all we really care about is what did he know then? What didn't he know? Which is also incidentally part of the reason that you can't bring in part of these prior convictions of the the victims, and I use that in quotes, because Kyle didn't know that. He can't know that at the time. So he can't rely on the fact that these guys have a conviction or came out of a hospital or whatever, because he doesn't know.
Yeah, unless there are certain pieces of evidence that he could have pieced together based on things that he saw, things he heard, things that people said. You know what I mean? Like, so I think maybe the suggestion with the hospital bag is like maybe Kyle would have. But there's no evidence that came in of Kyle saying, "Yeah, I recognize that as a hospital bag." If someone had said, "Hey, that's a hospital bag," but even then, from Kyle's point of view, I don't know that tells you anything. And because you don't know what's in the bag. This whole thing about the bag and like what's in the bag and let's do an inventory of the bag seems a bit ridiculous because in the moment of truth, the bag is opaque. And even if it was clear, how are you supposed to be able to see it as it's happening in the dark? Yeah. So the whole thing is a little ridiculous. Unless you can really closely tie it to some sort of significance that Kyle had at the time of the shooting, like that night. You know what I mean?
If he does something like if he posted something like, I'm really glad I shot these guys. It was a lot of fun. I wish I'd shot more people that night. Then you'd be talking a different scenario. But what people really want is to put in this evidence to say, listen, he's this bad person. We don't like him. And I go, I don't care if we like him. I don't care if I'd go for a beer with him. I don't care if I'd hire him.
Right.
I don't care if he's a guy I'd throw out of my house or, whatever else. You can hate Kyle Rittenhouse. You can think he's the worst person on the face of the planet. You can think, he is the next Hitler. The question is, was he legally justified at the time? Because even bad people have rights to self-defense.
Yep.
So lots of people.
The man who promotes us all. The man.
I know.
Speaking of bad people who have
Hey, Nick, this is the first time that you're on my channel.
Oh my goodness, it is.
It totally is. That's awesome. Hey, I've been trying to get you on here for like forever.
I know. Thanks for having me. I'm glad I could make it. Your streaming schedule doesn't usually comport with mine.
I know. I get it. We're on a wildly different schedule. And it has nothing to do with the fact that I'm almost at 20,000 subscribers now. I get it.
No, I saw your message and about the stream, and I had church this morning, and then I checked, and you were still streaming. I'm like, oh my goodness! Well, I might as well pop on.
Yeah. We're going through super chats. We're doing the Nick Rekieta gig.
Oh, good.
Very slowly.
So, but we've got a lot of really good questions here though. So anywho, well, how have you been since Friday, Nick?
Great. Just kind of getting pumped for Monday, trying to figure out what to do about everything. I thought about doing my version of closing arguments. How I would maybe close it, but that also sounds like a ton of work. So I'm not sure.
Well, I heard you on stream basically give your impromptu thing, and it sounded pretty good.
Oh, thank you. Yeah, I would probably do like a 30-minute, like full thing if I decide to do it. But I'm not sure. I just put out a video, and I've got another video dropping. It's the video that's going to come out later is
from the first day of witness testimony, and my editor put together a compilation of every time Legal Mindset, Viva, and I are screaming, object, object, not object. And it's quite a few.
That's a long compilation video, man.
So
I feel like the problem is that if you do your own closing, then we'd have to run them parallel, Richards and you. And that's really mean to Richards.
Yeah. I mean, it's like, oh God, I don't know what I'm dreading his closing. So I'm hoping I'm like, please, I was at church today, God. Please help Richards out. But
I hope he gets a stomach flu and Chirafisi has to close.
Yeah.
I'm hoping that he closes as well. Definitely hope so.
My black pilling will be a little less black if Chirafisi closes.
Barnes is of the impression that Richards will be closing. I don't know if he has particular knowledge of it or just if that's his read on it. So
I think he's right.
I mean, he's lead counsel. I would expect him to do close. Yep. I'd be very surprised if he did not. Yeah. But I still really just don't want him to go through a technical breakdown of the videos that the state's going to do and get into this weird, like I have this prediction that they're going to do this bickery argument over, well, like who provoked who and what was this? And it's like, if I did closing arguments, I won't go into it too much, but my opening line would be 2 minutes and 55 seconds. That would be it. That's the start. 2 minutes and 55 seconds. They brought in all kinds of videos. They want you to think that this event was this long drawn out thing and that all this stuff happened over the night, but 2 minutes and 55 seconds of this night mattered. It mattered to Kyle. It mattered to the people trying to kill him. And it mattered to everybody else in the right of self-defense. And like, that's where you start. And then you build from there, and you don't need to belabor all this. Well, they say he was threatening people at the other. No. Someone tried to kill this kid. That's it. And if they can distill it down to that essence, I think they got it.
It's probably going to start out with, ladies and gentlemen of the jury, the logarithms. And I'm just going to be like, oh God, no.
Here's what the expert said.
Oh, God.
If he gets to the logarithms in the first 5 minutes, I will throw something at my monitor, or really at all.
It's. Don't think about the logarithms.
Hurting me.
Sad.
Yeah, I physically have pain thinking about what's going to happen.
Well, let's get another super chat then, just to distract it. Doesn't self-defense get revived by Kyle stating to Gage he was turning himself in? Revive self-defense for the subsequent shootings? I'm not sure I understand the question.
Because he was trying to retreat? Sure. Yeah, that makes sense. So because you have to retreat and give announcements. So for the subsequent shootings that he was retreating and announcing that he was retreating, so he was disengaging. Yeah, maybe that makes sense.
Possibly. Again, the main issue with all of this is that you're asking a jury to determine what level of retreat and notice is adequate. And it's like, what do they think is adequate? Because what I think is adequate is, him running away, but someone else might want a letter written to Joseph Rosenbaum or whatever.
Well,
and cynically, baby.
Cynically, if the jury comes to the conclusion that Rittenhouse just cynically murders Rosenbaum, do you really think they're going to be super forgiving of these subsequent killings? No. If they get to the first murder, they're going to be looking at every other, if they get to murder on the first, they're going to say the second and third are obviously wrong too.
Yes.
Okay, wait. So, damn it. Kurt, help me out here. So I'm looking at self-defense, right? In the statute in Wisconsin. And we had all this argument over the jury instruction on the reckless discharge or the reckless endangerment, right? But here I am reading section 3 of 939.48, and it says the privilege of self-defense extends not only to the intentional infliction of harm upon a real or apparent wrongdoer, but also to the unintended infliction of harm upon a third person. except that if the unintended infliction of harm amounts to the crime of first degree or second degree reckless homicide, homicide by negligent handling of dangerous weapon, explosives, or fire, first degree or second degree reckless injury or injury by negligent handling of a dangerous weapon, explosives, or fire, the actor is liable for whichever one of those crimes is committed. None of those are. Reckless endangerment is not any of those listed.
I guess the only thing is that the crime sometimes includes the attempt. So it would also be the attempt to do one of those things.
But he's not charged with that.
Well, he doesn't have to be charged with it, I don't think.
Yeah, I don't know. Maybe when you're thinking about it, give it a look and let me know what you think.
Yeah.
I mean, if they botched that jury instruction because they didn't read that statute, it's just one more thing I'm going to uppercut them in the anus for.
Just a road trip just to, find these guys and go slap.
I wish I had seen this when Good Logic was here. I don't remember what he was talking about. How was he going to stop them if not by shooting them?
Asking nicely.
Do you remember, Kurt?
Mean looks.
Running him over with a tank.
I think this was with regards to the arrests possibility / scenario.
Okay. Can we take a moment to acknowledge that lack of empathy for Kyle's PTSD while on the stand is a display of psychopathic behavior? Psychopaths lack empathy. Yeah.
I don't understand.
The people on Twitter who are showing a lack of empathy don't seem to be going basically, ha ha, he's got PTSD, this is hilarious. What they mostly seem to be going is, we don't believe it.
Crocodile tears.
Right. Yeah, and I was making this point somewhere else too, but it reminds me of that line from Breaking Bad, where Mike Ehrmantraut is talking about Lydia when she's saying, I wasn't responsible for putting that GPS device on the barrel, and Jesse Pinkman says, I believe him, and Mark Ehrmantraut says, kid, when someone has a gun to their head, everyone is Meryl Streep. Right. So this idea that, it looks good. It's like, well, Kyle's on trial for his life. So maybe he's just because he's on trial for his life. Maybe that's why it looks so good. So, yeah, I think you can disbelieve it for that reason if you were so inclined.
Yeah.
Dragon's Treasure is here. I want to go pimp Dragon's Treasure some more.
By the way, Dragon's Treasure. I should have mentioned. I actually just bought tea for the first time, so I'm excited for that to come in.
Dragon's Treasure makes fantastic tea. It is wonderful and very enjoyable tea, and it is handmade and handcrafted. I'm not even being sarcastic. It's great. You should check it out if you're into teas. It's very, very good tea, and I really enjoy it, and I think you will too. So check out Dragon's Treasure for tea. It's awesome.
Water Jabbers, no offense, Nate, but this is why I would never hire a liberal lawyer to argue a firearm self-defense case, because this is the defense I would expect. I can't remember what we were talking about exactly when.
I'm pretty sure. If memory serves correctly, I think Nate had done the changing frames of reference thing, where he's arguing from a different frame of reference.
Yeah, because Nate is actually pretty strongly for the Second Amendment.
So I remember when this comment was being made, and it's just the same thing I run into too. It's like, I've changed frames of reference. I thought it was pretty clear, but people are confused, and now they're calling me an idiot, so it's annoying.
The other thing you have to think about whenever you think about, like, what kind of political framework do I want my lawyer to be from, is you never want a lawyer, whichever side, to be drinking your own Kool-Aid. You want the lawyer to be able to look at things, because if the lawyer is breathing their own, off gas, they can get into a place where they're making submissions that they think are great, and the jury doesn't. I think that's a problem with Binger. I think I understand Binger a little better watching his most recent thing, because what I think they've been doing is I think they've been sat down and said, you got to find a way to convict this guy. They went and they generated this video, and they think that that's proving it, and they're buying it. They think it's okay to do whatever to get this guy because they've convinced themselves that he's guilty based on this really stretched theory. But that's the last thing you want in your, if Binger's not playing well for us, do you really want to be the defense equivalent of Binger?
Right. Yeah. Do you want to run that risk that the jury's just going to get just as annoyed at the defense? Here's another question. The prosecution made the argument that Kyle's gun had ample range. Why not use that against them? Kyle can kill from 300 feet. So why were the only people shot the ones that ran right up to him?
That'd work too. That's a nice idea.
Yeah, I would think so too.
That folds nicely into Runkle's impromptu closing.
Yeah, I think so. That especially really pointing out that he literally waited until the last possible moment to shoot Rosenbaum, until his hand was literally on the gun. He had so many opportunities before that point, and he tried to not shoot him, essentially. So let's see. Here's another question. Why can't Gage shoot him now? Today, then, according to this line of thinking, can he shoot Kyle a year from now? Common sense demands acquittal.
I'm not sure I follow that argument.
I don't know what he's responding to, but I agree. Common sense demands acquittal.
That.
There we go.
I don't understand it, because I assume what this is going back to is this idea that Gage had a self-defense claim in the moment.
Oh, that's true. That's true.
So what it seems to be implying is, if he had a self-defense claim in the moment, why doesn't he have a self-defense claim a year afterwards? To which the answer is, because it's a year afterwards. It's no longer imminent. So I don't understand this, if I'm understanding the question correctly.
Yeah. So here's another question regarding Gage and thinking Kyle is an active shooter. Would you ever go up to someone you think is an active shooter and ask, where are you going? I mean, that's fair. that is kind of a fair point.
He might not have thought he was an active shooter in that moment when he first approached him, and then because he's asking who shot, and then apparently comes to the conclusion that he shot, and then started chasing him. So
Well, he also just watched 2 more shootings.
Yeah.
Yes, that too. At the point where he pulled out his gun. Yes, exactly. So.
Yeah. So,
but all of this, and this is the danger of how this case was handled. All of this talk about the mental state of Gage Kreutz doesn't matter. It's not relevant to Kyle's mental state.
Right.
That's relevant to Gage and a claim of his attempted homicide. For example, if they were charging him with attempted homicide of Kyle Rittenhouse, his mental state of he's an active shooter becomes really, really relevant. But Kyle doesn't. He's not. Let me have a colloquy with you, Mr. Kreutz. Are you engaged in a mental state that I am an active shooter? If so, I need to revise my mental state and determine how to appropriately, like that doesn't matter. And that's the confusing soup that the prosecution has been working on the whole time.
Yeah.
And it's why I'm really worried about closing arguments. If they get bogged down in these weird, this person was provoked, this person had a thing, this person, none of that matters. And the only reason you would have Kyle testify at all against all advice and all wisdom is to get his state of mind. And they did. And so if you put that card in the ATM machine, you better cash out and just focus. He was fighting to defend his, you've heard him say it every single time he was asked over and over by the state. I was defending myself. I did what I needed to do to not die. That's it. That's what he did. And that's where they got to focus. If they worry about all this other shit and trying to disprove other people's state of minds, I mean, they're going to be bogged down in bullshit. Sorry.
I completely agree. And that, I mean, you weren't here for our discussion earlier, but we kind of touched on that too. I mean, that at the end of the day, the only state of mind that matters here is Kyle Rittenhouse's, and the defense has to make that super crystal clear for the jury.
Yep.
So here's a question. How can you add charges after testimony is done? Who wants to answer that?
I mean, they're
lesser included. Yeah. So the higher charge implies the lower charge.
I think theoretically, after testimony is done, they could also add additional charges if they believed they elicited probable cause sufficient to add the charges.
That's true too.
So if extra evidence came out, like there was some sort of surprising, damning testimony that nobody really knew about, that just somebody had blabbed on the stand, I could see that happening more so in Hollywood than anything else.
Whole time, yeah.
Right. Well, like if you're on the stand for drunk driving or whatever, and you say and you got in an accident, and then you say, actually, no, I know that guy, I saw his license plate, and so I tried to hit him, that son of a bitch. Like you're gonna catch another charge.
Yeah. Or if they say, well, where were you going? Where were you going from? And you're like, oh, I was actually just dropping off a hooker that I had picked up. Like, something like that could do the same. So, is the guy in the wheelchair wearing a spacesuit and helmet, or does adding pixels distort an image?
At a BLM Antifa riot, you never know what someone's wearing.
Fair point.
Well, I mean, there was all sorts of improvised protection from tear gas and so forth. So
yeah,
I've learned how to make at-home tear gas, though. That's nice.
I must have missed the recipe.
Yeah, I think I missed that too. That would be very helpful for the pending zombie apocalypse whenever that happens. If that happens, I would definitely want Grambo on my team. If I have anyone on my zombie response team, she's number one on my list. Let's see. On the subject of Gage's testimony, there is no world that exists that someone who has gotten a concealed carry permit can logically claim, I would never shoot someone. Why carry if you will never use it? We totally agree.
It's a strange proposition. I guess the only reason would be because in some states, if you have a concealed carry permit, you can get an expedited background check because you already have the permit. So if you got the concealed carry permit for the purpose of purchasing further firearms with more ease, then I guess that would work.
But then he goes and buys the gun and carries the gun.
That part's a little bit
loads the gun.
That part's a little harder to explain.
Chambers around.
That part's a little harder to explain. Yeah, that's more difficult. Yeah.
Also, I clicked out of the last super chat a little too quickly. Nate's over under. He didn't actually give his over under specifically, but I think before that point he had mentioned that he thinks that more than anything, I think he said it is going to be a hung jury. I think, if I'm not mistaken.
And what are the over under? What is the over under, Nick?
Yeah, what is your over under?
On
guilty,
jurors?
Not guilty, or mistrial.
I think it's going to be a mistrial. I think the provocation argument took away what sort of minimal chance there was for a full acquittal, because I think it muddies it up too much and gives people a nice excuse. But I think it'll be a mistrial. I don't think he's going to be found guilty on any of the charges, but I do think he's going to. I don't think he's going to be acquitted on all of them. He might get one or two. He should be acquitted for all of them, but I just think it's going to be too confusing in the jury room, and it's such a polarized case.
Yeah, no, I agree. Did you guys see the photos and videos that Jack Posobiec has been putting out? How can some dudes on the internet be better than the defense witness?
Good questions.
I don't blame. I would not blame the defense witness. I would blame the defense for not asking for what they got.
That's a very good point, because I mean, ultimately they're required to answer the questions that are asked of them. They can't necessarily supply more information. Obviously, with a direct testimony, there's more leeway because they're supposed to ask open-ended questions. But even still, the framing has to come from the attorney asking the questions. So here's another one. Let's see. Real question. When do bad actors become good actors in mob rule? Also, remember Huber hit Kyle twice, once while he was running and had the gun pointed down.
I mean, the same way a good actor becomes a bad actor. It moves from moment to moment. Someone could be a bad actor and then see a fire and then decide to put it out and then go back to being a bad actor. So, you have to kind of analyze it as it happens, I suppose.
Yeah. Same thing. Yeah, true. Could each of you please take a turn at pronouncing Ross Kreutz's name?
No, I'm good.
Gross Kreutz.
Gross Kreutz. How about you, Ian?
I think I'm gonna miss more syllables than he's missing, biceps. So I'll just leave it.
Okay, let's see. Faking a surrender is a war crime. All right.
Only if it's actually a war, though. That's the thing. Is lots of stuff. Is war crimes that you might do on the regular. If you pepper spray somebody, that's a war crime.
Against war, but you can use it in self-defense situations. So whatever.
Well, and where I am, it's required for use in hunting.
There you go.
Yeah.
Is it really for Hot Point?
Yep. They won't let you hunt big game without expanding ammunition.
Okay.
Could the provocation instructions be grounds to bring in Rosenbaum's and Huber's priors?
No,
I don't think so.
Not
because
unless
the provocation. Yeah, because the provocation claim is just that's it brings in the moment evidence. That's about it.
And their closing argument has to be based on evidence in the record, and they don't have it in the record. They foreclosed that path. So
right, yeah. Let's see here. I'm trying to find more super chats. Okay. If you watch the video, Gage Kreutz was pretending to give up. Kyle was going to let him go, and then he aimed his gun at Kyle. I mean, could be. Yeah.
I don't know that you can infer anything because it's so fast. I'm not sure you can infer that.
We can only infer it in the like 3 FPS slowdown that we get.
Yeah.
But like in real time, he shoots Huber, and then Gage is shot 4 seconds later. Like Huber hasn't even fallen to the ground, or is just hitting the ground as his bicep is disappearing. It's so fast. I don't know.
Well, and the other thing is, we talk about him pretending to surrender. He might have not actually figured out what the heck he's doing at that point. He's like, do I surrender? Do I shoot him? I don't know.
Yeah. A bit of a digression from the current conversation, but did Legal Eagle cover the Rittenhouse case? If so, how dishonest was he? I haven't seen anything on it. Yeah.
I think it's one that he's going to have a tough time covering just for reasons I'll leave.
Yeah. I wouldn't be surprised if he leaves this one to us.
I think he might do commentary after it's all done. I don't think he's going to make a comment before then. That's my bet.
That makes sense. If Kyle is convicted, can the judge, knowing that his decision on including provocation was weak, remand him to house arrest until his appeal is heard?
Yes, he can keep bail open while the appeal is ongoing if he wants to. You would not expect that. You would expect him to be remanded, but it's technically possible.
Provocation with a Hail Mary.
Never covered Kyle Rittenhouse. He covered Arbery. He covered Floyd. He's covered Alec Baldwin.
I don't want to watch that one. I don't know what his conclusions are.
But I mean, he has never covered Rittenhouse.
Interesting.
That's surprising to me.
Yeah.
Well, I mean, Rittenhouse is a tough one if you're trying to take particular views because the evidence doesn't go that way.
Here's a question. Why doesn't the defense show the judge who asked if Josh had his gun out at this point in the courtroom and the prosecution lied to him? The video of Josh with the gun, judge said he wouldn't add the provocation charge. I'm not sure I understand this question. You guys
show the judge.
You guys understand it?
The judge who asked if Josh had his gun out at the point in the courtroom, prosecution lied to him. Oh, that was a weird exchange where they're looking at the video, and the judge the judge asked if Zeminski had his gun out, if the video showed Zeminski with his gun out, and they said no. And then Richard said he had it down at his side. He didn't have it holstered or whatever. He just had it down at his side. But I mean, the problem with that video is you can't see anything about what's going on. I mean, that's the issue there. So
one of the biggest issues.
Richards lost, in my opinion, Richards lost the provocation argument when he said, even if we accept it all as true, is it even provocation if he pointed a gun? It's like, of course it's provocation, you weirdo. Why would you ask that? And then he just created a jury question where one didn't exist. So that's on Richards. It's on Richards. It's something that you never want to do.
Can you guys not send this to the defense lawyer's email? Kyle's life is on the line. Our self-defense rights are on the line. I mean, unfortunately, we don't all have each other's emails. I've never met any of the attorneys involved in this case. So I definitely don't have their contact information. I mean, you could probably get it from their firm website, but I doubt that they are taking any kind of emails from anyone at this point right now.
Yeah, if I was doing a case like this and some random YouTube lawyer sent me an email that said, you need to change your closing argument, I would just laugh and ignore it.
I'd say get off my lawn. His Yellow Pants Guy video shows Yellow Pants Guy illustrating how Kyle is holding his gun that Crypto Dark has on his feed. Oh yeah, Nick, have you seen the videos by so we were showing some of those earlier. Those were really interesting. I hadn't seen them before that point actually, so I'm glad that we took a chance to take a look at those. How is what Binger and Lunch Break are doing not illegal? He is literally lying about evidence and claiming things that are physically impossible. Rittenhouse aiming with a laser at someone.
Welcome to prosecutions. I don't know.
Yeah, I mean that's kind of the nature of litigation. Is it's also up to the defense to sort of take the prosecution to task when they're doing really, really egregious things too. So it's kind of the nature of any kind of litigation, whether it's criminal or civil. So Barnes, who was on the case for a bit, said in a late night stream with Ricada like 2 days ago that Richards will be doing the closing. Yeah, I think somebody mentioned that earlier. Yep. Same.
I mean, normally the lead counsel would do the close, but this might be a time to make an exception.
Yeah. If surrounded by people on top of cars and fire, sometimes both, armed with pipes and other blunt force objects, would it not be justified to raise one's rifle at a potential armed suspect who isn't even visible on film? I mean, it depends on what that person's doing, I guess, because I mean, just because somebody else is armed, there are a lot of people there that were armed, right? So it depends on other circumstances what they're doing.
I mean, you can make this argument in terms of the use of force being a pointing a firearm to deter somebody. The problem is that Kyle can't make this argument because he specifically denies it. So Kyle is saying, you know, when he was asked, did you point the firearm? He's like, no, my rifle is down in this shot. So you can't say, hey, I was justified in pointing the rifle if your argument is he wasn't pointing the rifle.
Yep. And I don't think you want to. Like, I don't think you want to get into this idea that he might have raised the rifle. Again, once you say he might have done something.
I mean, there's arguments you can make in front of a judge, and there's arguments you can make in front of a jury. And the alternative argument is a judge-only argument. The thing of, he didn't do it, but if he did do it, then he did it in a way that makes him innocent. That a judge will listen to both those arguments. A jury will just hear, he just admitted he did it.
Yep.
And, you know, then you're done.
So, I'm going to post the links to the Darth Crypto videos on Twitter. I'm going to post links to those in the description in a minute. So thanks for asking for that. Let's see here. Sorry for the dead air, guys.
You're fine.
Seeing some of the Weasley arguments that Binger and Krauss have made, it's kind of a black pill on the justice system. Yeah, I mean, it is pretty depressing to see that prosecution will do this, but I mean, Nick, what are your thoughts?
I don't want to overdose anyone on black pills. No, I'm not a fan. I'm just not a fan of how prosecution is done. There's a lot of reward for bad actions, especially in high profile cases, but it's not limited to high profile cases. I mean, something like 85+% of prosecutions end up in plea agreements. And the reason is because they overcharge intentionally and then offer people the alternative of pleading down to a lesser offense. Again, I do not have an extensive practice, and a prosecutor in Minnesota called me out in one of the comments, says, you've only been on this many cases or whatever. He's like, how could you know this? And my response was, it only took one. It took one case for me to see prosecutorial misconduct, or what I would consider that. And just a very brief story. I was representing a woman accused of domestic, or no, this is a different one. I was representing a man accused of domestic violence. He had been dating this person forever, but they were not married, and she had a son from a prior relationship. Well, turns out he came home and the son was getting into a physical altercation with the mom. So he stepped in to break it up, and he did not hit the kid or anything. The kid's like 16, and he just grabbed around his body and pulled him away. And then the kid got away. So they ran outside. They followed him outside. He hit the guy in the face with a shovel, and then he was throwing rocks at him and the mom. And then the kid ran off, and the kid got arrested later. Well, so the mom helped hire me and gave me a letter. It says he's never hit me ever. He didn't hit me here. All of the violence came from the kid. That's what happened. And I brought that into the prosecution. He said, too bad. Women lie about this stuff all the time. So I'm going to still go through with it, and I'll get her testimony stricken because she had a prior crime of dishonesty. And so then when we get to the pretrial hearing, the kid that morning confessed to the exact narrative that I just told you. The kid confessed to doing everything. And I said, all right, you ready to drop this case? And the prosecutor said, no, I'll get the kid's testimony removed. He was still going to go. I'm like, wait, so the mom's story is consistent with the kid who just confessed to the crime, and you're going to try and run a domestic violence charge on this guy who no one has actually accused other than the kid when he lied earlier and has now admitted he was lying. And he said, yep. And we ended up getting, we got that case dismissed, but that was his plan, was to go through with the charges. Wow. You find this stuff all the time. I am not unique. Like, I have not found the only bad prosecutors on earth. It's how it goes. So.
Well, I'll try to defend the prosecutor, and you can tell me why I'm out of my mind. But you could imagine in a domestic violence situation that someone would change their story. You could imagine the woman doing it, changing the story. It's certainly happened. It's suddenly like, oh no, he didn't hit me. He didn't do nothing wrong. But it's like, yeah, he totally did, and you're just lying now. So the fact that he is now trying to go to narrative, I could see a good faith prosecutor saying, this kid is just lying and he's confused or whatever, so I'm going to press on. How am I doing? Is this redeemable?
Up until the kid, the mom, some women do change their story, right? Like they get hit and it's because they don't want to get hit again. Makes a lot of sense, even though they're going to get hit again. That's how it goes, unfortunately. But that thing, I can't break up the home life. I need him to make to bring home income or whatever it is, whatever reason that does happen. The main reason at first I was frustrated is because she's the only witness. Like, other than the kid, she's the only witness, and so it's like, here's your witness is this person who's not going to cooperate with you. So you should probably just, as a practical matter, drop the case. But when the kid goes in and confesses to the crimes, it's like, you have no case now. You have none. And his whole way he was going to get that case was to exclude the state's own witnesses from doing it and prosecute it based on, I can't figure out what testimony, because the two witnesses are the mom and the kid, and he was going to disqualify both of them for dishonesty. And it's like,
unless you have physical evidence, you have an evidentiary problem for sure.
And the mom had no bruises.
But I could see a kid being manipulated by. It happens in divorce cases where kids are manipulated, and try to use it to get at each other. So
that kid was in jail the whole time, so I don't know how they'd manipulate it, but it's theoretically possible. But I'm not into it.
All right, fine. I was just trying to defend the castle. It's always fun.
Any information on the allegedly doxed juror? Is this maybe referring to somebody that tried to take photos or video of jurors of the jury getting on the bus or something?
Might be. I don't know, because that was all of the jurors, from what I understood.
Yeah.
Like they took a photo of several jurors getting on the bus. But I haven't seen the allegedly doxed juror in any other way. Although people have sent me that I have not noticed, but they've sent me little messages that says, "Hey, the jury was photographed by the live streams when they panned over or something." I think they're probably mistaken, and that it was probably a different courtroom person, but I don't know. I've never looked.
Yeah. So let's see. So this is talking about the Ahmaud Arbery case that we were talking about that earlier. Those dudes probably are racist, no doubt, but I wouldn't put it past a criminal to case out a place to rob by posing as a jogger either.
Yeah, no, that's not the issue. The issue goes, again, you have to change various frames of reference. So it's like, was Ahmaud Arbery doing a bad? Okay, you can come to conclusions about that, fine. But then the conclusion goes to, like, their knowledge base and whether or not he was escaping or not. So fun times.
Yeah. Here's a good one. Am I the only person that thinks Runkle sounds like Jordan Peterson? No, I think I kind of agree. I can hear it.
I've really got Jordan Peterson.
You don't know what Jordan Peterson sounds like?
No, I do know. No, I love Jordan Peterson. I'm a huge fan of his. I've seen him live a couple times, and So I'm a Jordan Peterson fan. I think his stuff makes sense.
No, I think that's a wonderful compliment. He's great. Agree with claim. Men often expect construction sites?
Again, I have to say that this does go to my experience, even as an adult. Yes, I have gone on to open construction sites to look around. I've been driving through a neighborhood or a subdevelopment that's in the process of being developed, and there's a house that's, partially constructed, and there's no fencing or no signs. And yes, I have gone into those houses to look around because I'm curious and geeky like that. So I don't know how common that is of other people, but that is a thing that I have done. So yes.
7,000 trespass torts have just been filed against.
I want to see how houses are built, because it's when you see a house, it's like, oh, there's just a house there. Isn't it cool to see? Oh yeah, the beam gets connected here and the thing gets connected here. It's just kind of cool to see the parts interrelated. Is this just me? Is it just me? Bueller?
In my area, the prices of everything have gone up so high that the fence goes up first, and everything is fenced off, and we'll have cameras hidden through it. So
no, but I mean, I agree. I think it's natural to have a curiosity about a construction site that's totally open like that, and especially if there's no one around. I mean, I can see that, and I could see myself doing the same. So, let's see this one. It doesn't take 20 hours to make that single picture. So where are the rest of the pics created by the prosecution expert Photoshop guy? Oh, so I think they're referring to the infamous modified picture. Yeah, that's a fun one.
Look at this photograph. Every time I see it, makes me laugh.
Should you invite Kyle defense team to panel to ask? I don't think they want to hear from us right now.
Or ever.
Yeah, maybe not ever. Yeah. Let's see here. I would hope they have someone watching Twitter and social media. I mean, maybe someone at the firm is watching, but I don't know. I don't know how much they're filtering any kind of information like that. Someone wanted me to slow-mo the chat. Sorry. Yeah, there was a good period of this stream earlier that we had some massive trolling happening, or spamming, I should say.
They're coming from your chat, Rakita. It's the same people that were in your chat that we had to put on the bans for. So they moved over. So thanks a lot. That's great.
Yeah,
well, you know what? You get what you get. Take that.
I guess so. Yeah, I mean, I think I finally just added enough mods in there to sort of help figure that whole situation out. So remember, uncivil law, you're planning to pass the bar for Texas, not Georgia.
Yeah, great.
Yeah, no, but I think that'll be. I have a lot of optimism for you on the Texas bar. I think you'll do fine.
I think I'll do fine on the multi-state. I do need to refresh myself on.
Wait, you haven't passed it? Oh yeah, because you used to practice.
I'm a Virginia lawyer.
State. I was like, my brain forgot that. Sorry.
Virginia's a different state than Texas.
I mean, sometimes.
And remember, it's a big deal if you're crossing state lines.
Carrying the law across state lines. Let's see here. Okay, so next one. Best thing to do about it is this: adults need to protect Kenosha themselves. If you know what I mean, the failure of adults is what caused this. Well, I mean, maybe not having the National Guard. That was probably one of the big reasons here. Oh, I think this is referring to Good Logic talking about Susan taking away a bunch of his subscribers.
Happens to all of us.
Yeah. Oh, here's one. We love you, Kurt. Yay. Yeah, Kurt was beating himself up earlier, Nick, because of an analysis on Georgia law, which you're not a Georgia lawyer, so you know.
Yeah.
And
Kurt,
now we know why.
Oh, no. Kurt, I want to play live music next to your door to keep you awake. No, that's mean. Don't listen to them, Kurt. I think gloom pills are in order, and we should bring out the sad violin. Let's crush up these doom pills and stiff them up.
Awesome.
My opinion on Richards is he is human. Everyone was screaming object, but at the end of DA arguments, it looked like just the facts, and that was working. I mean, I feel like I say this all the time, but we'll find out when the jury returns a verdict, I guess. So give it to me straight. Is Kyle going to make it?
We have a divergence of opinion on that one. I mean, we're all guessing, so it's not like we're all guessing.
Yeah,
so
no one can know for sure because we don't know what the jury is
and juries
thinking.
can always do weird shit.
We're trying to predict the future.
Yeah, juries can always do completely weird shit, and so who knows?
Yeah. I mean, but it is optimistic that they were able to take notes during trial. I know I mentioned this the other day, but not every court allows that. So yeah, it's good because that way they can come back to information that they may have forgotten already from the beginning of trial. So that'll be very, very useful. Yeah. Would it be a different judge if a mistrial is called?
Don't know.
I'm not sure.
I don't know how it works in Wisconsin.
I think Barnes indicated that it would probably be the same judge unless something were to happen, like he would get sick or retire or something like that. But I don't know the rule. That's the most information I have on that subject.
Okay. If there is a retrial, so this is another same question. Okay. If Kyle had finished Gage Grosskreutz because he was still holding a weapon, would that have been better for him? Oh, as in if he had killed him.
I mean, he'd be facing more serious charges, and he wouldn't have had Gage Grosskreutz's testimony, which was fantastic for the defense.
This is fair. Yeah.
It's
probably better. Probably better with him alive.
Yeah, I would say so. That is a good point. If Kyle was just shooting people, wouldn't he have finished off Lefty the Lefty? Yeah, I guess so. Gage Grosskreutz was moving that arm quite well during the hearing for having his bicep vaporized. If there's a retrial, his current actions will be brought up and will show he is a repetitive liar. All right. Thoughts on being a rebuttal? Oh, is in for the closing argument, maybe. What do you guys think is do you think he'll save anything for rebuttal? And if so, what?
Yeah, he's definitely going to save something because you want to cap off. You have the opportunity to cap off and be the last impression for the jury. So even if you just save a couple minutes to go out and say, he came into our community and now he's killed 2 people. I mean, even if that's it, you
got to have something. I mean, sometimes you can wait and see and come up with something while they're talking, something to say, they just said X and here's why that's BS. But they're not going to want to leave the last word.
Yeah.
Mm-hmm. Did you guys hear Richard's objection while Kyle testified? Binger asked him a question. Richards objected and said the gun was in his face. Kyle was then able to answer something similar. Teamwork. I don't remember this part for some reason. Do you guys remember?
No, but it wouldn't surprise me.
Yeah.
This kind of thing could be... Oh, sorry, go ahead.
Sorry, go ahead. No. You finish your statement.
That kind of thing can be dangerous because if you suggest something to the witness and then the witness parrots it, here at least the jury might get an instruction to say, hey, you should put less weight on that because, it was just fed to him by the lawyer.
Yeah. I mean, I haven't heard that in American trials. How about you guys, Kurt and Nick?
I've never heard of the instruction, and I think someone on the panel even said while some of that was happening that the interesting part about the ability to object is sometimes you can cue in your witness to what they should be saying or not saying, and I think as long as you don't do it excessively and obviously, if you have some basis for an objection, even if it's wrong, the judge is going to let it happen because you have a right to raise objections. Even when in some cases down in Texas, a judge will tell you to sit down and stop objecting, but
Yeah. Well, that may have actually been me that made that comment. The same thing is true also if you are on direct and you're asking, leading questions, and then they start objecting to your leading question, but you're like, all right, now you know where I want to go. Let me ask a more generic question. Go where I want you to go. Let's see here. Wouldn't screaming friendly, friendly while retreating signal that he was disengaging and privilege him to sure self-defense again? I mean, that would definitely, I would think that would be evidence that would help his self-defense claim.
I don't know that he was screaming friendly, friendly while retreating.
I think it was different timing.
I think it's different timing.
The other thing is, and I'm sure you guys have been harping on this, but I'll do it one more time, is that there is no sure self-defense anymore. Like it's jury's interpretation of what self-defense is. So we can make legal arguments. We can talk about the legality till we're blue in the face. But once things get in the hands of the jury, and this is why the provocation instruction is so frustrating, is that there's no, like, the legal standard almost doesn't matter anymore. It's now the jury's feelings are what's on trial. So to some extent, I mean, they can very much say that they're trying to apply the law, but at the end of the day, it's through their lens. So, yeah.
Very true. Can counsel demonstratively show exhibits already in evidence during their closing arguments? Could the defense show other video angles which don't show Kyle pointing his rifle at Ziminski? Yes, that's ideally what you would want to do.
Yeah, just if the defense could avoid showing the one frame where there's a circle around Kyle Rittenhouse that says Kyle possibly pointing his gun at or could be pointing his gun possibly at Ziminski or whatever. Like, if you could just avoid showing that one to the jury defense, if you can manage that for a day, that
would be ideal. That would be ideal, right? Too much nose for one stream. I mean, I can't join in the fun because I've got a nose too. Jack Posobiec on Twitter had videos showing Kyle never raised gun, how incompetent the defense never entered these into evidence. I actually haven't seen those. I know somebody else mentioned them in another super chat earlier. Have you guys seen those? Is that anything new that wasn't introduced at evidence?
I don't know, but if they're enhanced, it's the same problem, right?
Yeah, there's a bunch of zoomed in and slowed down videos that are really clear and really nice, but yeah, they're still technically enhanced. The other problem is the defense, I think, is caught off guard by the raising gun argument, because they've done remember that drone footage. First of all, the FBI drone footage that they also claim he does the raising gun, which is nonsense. It's not in there at all, and you can't see it. But that footage came in just before trial. The other footage came in the middle of trial, and that's the basis for almost all of their stuff. Remember, the only testimony that Kyle raised his gun came from the cop who looked at the drone video. I mean, that's it, which should have been objected to immediately. Yeah. But so I think they were caught completely off guard by this whole theory that he raised the gun at Ziminski. And so, I mean, I actually am not going to fault them on not introducing into evidence a bunch of video that shows that he didn't raise the gun, because all of the video that they have, they've never even heard that he's raised a gun, because he didn't. No one's ever claimed this. One random cop claimed it on an enhanced video that came in on the Friday during the trial. So it's when you think about how unfair that whole line of thought is, it's really enraging. But they didn't object to a cop testifying to what he did and what he saw on his pinch to zoom iPhone that couldn't be replicated.
Yeah. I mean, the other part of that, though, is, like, at that point in trial, like, I know that for me, I was starting to get fuzzy-headed on details and whatnot. And I'm sure that the jury was feeling that way because they weren't able to have fizzy water and Oreos and snacks brought from heaven, during trial like I was. So
drink your Red Bull.
There you go.
That's what you got to do, is drink your Red Bull.
Yeah. But the thing is, like, them introducing that at the end of trial on the very last day, like, the jury's probably already thinking at that point, or they could have been thinking at that point, like, hey, we're almost done. I'm done. I'm done. I'm out of here. I don't even know what you're trying to show me. I don't understand it. There's no story with this. You're just showing me a couple images. I don't know what that is. Everything's blurry. So that's at least a hope. Maybe I'm just on a little bit too much hopium, but that's what I'm thinking. I am in Kenosha. If you were here, would you go to the trial Monday for closing? I don't think that you'll be able to get in, because it's probably like only media only, my guess. And even at that, I doubt that everyone is going to be able to get into the courtroom, because it looks from the live streaming that it looks like people are socially distanced in there.
Have you got a bunker you could hang out in instead?
Yeah, that might be a little bit better, because I would also be very concerned about personal safety.
Yeah.
Congrats on getting Nick on stream. Yeah.
Oh, I hate to right with this one. I hate to say
you gotta go.
I gotta go. I gotta start on. I've got a long item to cook for dinner, so I gotta get out of here. Sorry.
Okay. Well, before you go, can you say this in your Richard's voice?
Oh, sure. Your Honor, motion to get Runkle to I don't even know what this means. To show doggo. It's a technical term, Your Honor. Can we show that on stream, though, Your Honor? Can we get a ruling on that?
That was awesome. Awesome. Well, thanks for joining, Nick. Even for just a little bit. Yeah, have a good dinner.
Yeah, once this trial's down, I should have some daytime when I can pop on and do a show,
Okay. So. Yeah, that'd be great. That'd be awesome. Guys. Yeah, thanks for hopping in.
Catch y'all later.
So, and then Ian and Kurt, are you guys still good, or do you need?
I'm still good, although I may have to respond to a motion, so I'll be right back.
Yeah, sure, no problem. All right. Guys, Rick from Good Luck America on YouTube is an interesting personality that perhaps Nick could interview as a guest one day. A gun guy. Oh, I wish you would have seen this. I'm so sorry. So odds on Binger getting disbarred.
0.
Oh, sorry. Did you want to respond to that?
No, it's just like, I'm a gun guy, but no, it doesn't matter.
Oh, okay.
Yeah. Odds of Binger getting disbarred, 0.
Yeah, probably.
Odds of him getting sanctioned are probably 0. I was covering this yesterday on Nick's stream or something. There's an article written. I'm gonna get the.
Yay, doggos! Yay!
Yeah. I'll get the gross numbers wrong, but I'll get the percentages right. So, over like a 5 or 6 year period, someone did a study, and even in cases where the prosecution there was a directed verdict, or there was a lessering sentence, or otherwise in terms of like really egregious stuff, the prosecution's only got ethics referrals 2% of the time. So basically, prosecutors don't ever get referred to the bar, and even when they do, they never get punished. So your odds of Binger getting punished are basically 0. So the dogs went away.
Yeah.
They might have started to get barky.
I definitely understand that one.
I feel bad now, because now I talked completely over dog time. I thought it was going to last longer.
Oh no, that's all good.
What do you lawyers think of YouTube removing the dislike metrics from viewers? I personally, I hate it. I think it's 100%.
I'll give it a dislike button.
It's 100% to protect media, like mainstream media, legacy media, however you want to describe it.
Yeah, I have yet to be dislike bombed, although I might have just opened the door to something I don't want to see. But I mean, the other thing is, for a small creator, if you get dislike bombed, from what I understand, it's not actually necessarily a bad thing. It's a ton of engagement on your channel.
Yeah.
That's what I've heard too.
But what it does is it embarrasses, the bigger players who post something, get proven wrong, and then everybody goes to their channel or to their video to dislike it, and they're like, "Oh well, whoops." Yeah, why have a like button if you don't have the option to say the other one?
Yeah, for sure.
I'm just waiting for the left to start screaming about the fact that this means that they can't dislike all the alt-right, far-right videos anymore and show what trash it is. So I'm just waiting for that to be a thing.
Nice. Can Barnes somehow get that video analysis to the defense showing that the artifact is a mirror and not Kyle's hand, so they can argue the same point to the jury? So frustrating to watch Richards. I don't know. I don't know if Barnes is talking to any of them right now. I know it's kind of the same response as any of us trying to reach out to them. And I don't know if
better prospects because he knows them. But
right, exactly. Could Kyle use the Alec Baldwin defense? Well, he's not a celebrity, and he's not an Alec Baldwin celebrity, so probably not. I support Dragon's Treasure, and I'm sure their teas are delicious, but I'm going to wait 3 months to make sure the entire panel doesn't die before I try. I mean, that's not a bad idea.
Dragon's Treasure is secretly a Marcus trying to end us all. Okay, that's great. Runkle,
Did you see Miriam?
You can lead the charge when we're all gone.
Did you see Merriam-Webster tweeted out crocodile tears, and it's meaning the day Kyle testified. They ended up deleting it because of backlash. I hope so.
Nothing surprised me with Merriam-Webster. My personal favorite still was when the what was it in Congress? The woman from Hawaii was asking, wasn't it Kavanaugh? No, it was Amy Coney Barrett asking her a question about, what was it? It was asking, she used some terminology which apparently could be thought of as racist or disparaging, and Merriam-Webster themselves changed the dictionary definition later that afternoon to reflect that apparent perception. It wasn't in their definition earlier that day, but when the woman from Hawaii started saying it, they went in and actually changed the dictionary to add in the definition. It was sexual preference. That's right. Sexual preference. Amy Coney Barrett used the term sexual preference, and the representative or senator from Hawaii said, "Well, that's a disparaging term because it implies that people can change it because it's just a mere preference," which I'm not sure necessarily is implied, because I'm not sure you can necessarily just inherently change any other preference, but whatever. And then Merriam-Webster themselves changed the definition later that day within like 3 hours to say, "Oh, this is now a controversial thing." So Merriam-Webster doing shit doesn't surprise me.
That's annoying.
It's very
even if Kyle briefly pointed his firearm at Zeminski, how would Rosenbaum know that when he was on the other side of a truck? I mean, it would depend on his angle, and obviously he would have to see it. Well,
trucks have windows. I mean, it's a possibility, and so the jury would have to decide if that was what happened. But that'll be the open question.
Yeah, exactly. That's question number 1 on that issue. Isn't it obvious the state doesn't believe Kyle points his rifle at Kaminsky, or do they mean Zeminski, by the fact they never charged him with terroristic threatening?
No, even if they had terroristic threatening, no. To show terrorism, you have to show an intent to basically get the state to do something different, or you're nowhere near terroristic threatening.
Yeah. Let's see. They need to pick the most important points and keep hitting those, not fall into disprove Binger. Hit on time. Binger tried to mislead and confuse. I definitely agree. I think if they get bogged down in too many details, keep it really simple. That's probably going to be the best case for the defense. So, yeah. Let's see. Oh, thank you, Kevin Dorr. Okay. Fake or not, Gage's surrender doesn't take away from the fact that he chose to aim at Kyle a moment later. I don't think anyone would disagree with that.
I'm not going to read into his micro movements for the exact same reason I'm not going to read into Kyle's micro movements. Yeah. It's just too fast.
Yeah. I think right. And especially because at the end of the day, like I said before, the state of mind of Kyle is the one that is most important here. That's the core analysis. Are we blackpilling too much here? Richards is boring as hell, but the evidence for Kyle's too strong for me on the sidelines. Love from Minnesota.
I feel comfortable with my level of blackpilling, even though there's strong disagreement with the level of blackpilling. So yeah.
I don't know. I still am holding out some hope, because there's a possibility.
I haven't given up hope. This isn't that bad, but damn.
2 questions. 1, if Kyle is found innocent, are you guys going to have a stream party? 2nd, Ricada, that's the worst flavor Gatorade. Oh, I wish he had seen that. I wouldn't be surprised. I feel like Nick would definitely want to have an acquittal party. Does Binger have a future after this case as a prosecutor, or maybe a political future?
This isn't even going to slow his career down.
Yeah, I think that's right.
Yeah, I think so. I think that's also correct. I really have been enjoying the streams and videos going into a lot of detail on legal cases. Does anybody plan on covering the Crypto 6 out of New Hampshire? Trial is in November next year, I think. I haven't even heard about this.
I have no idea what that is, and I don't want to find out because I have too many things on the list. So no.
I'll make a note of it, just in case I have a chance to look it up. But if it's about cryptocurrency, that sounds kind of interesting. Let's see here. This whole kerfuffle has me trying to memorize the name of the lawyer that helped me a couple years ago. Don't speak without representation ever. I would definitely agree. Can judge limit Binger provocation to blurry pick since he told the judge that his basis and that he wouldn't use being there or armed as justification?
He doesn't have to use it as justification explicitly. He just has to hint at it. Yeah. And it not being sufficient for legal purposes and not being part of the closing argument are two distinct propositions. With even just a little bit of thought, he can bring it in and not legally use it, but the jury won't know the difference. So it's,
Right.
I wouldn't,
Ooh, we're finally catching up on these guys. Is Kyle's mom doing interviews going to hurt the defense on Monday? That's why the prosecutors brought it up, or just covering for Gage?
No, it doesn't hurt the defense because, of course, the jury's not seeing any of it, right? So, yeah.
Well, at least they're not supposed to be seeing any of it. I mean,
Assuming,
I would be telling her to stay in a hole personally, but I mean, you never know what mom is going to do. She might have been told, "Hey, keep out of the media," and decided to talk anyway.
Yep.
Yeah.
Yep.
It's not exactly like Kyle's been catching many breaks on this one.
Yeah.
Kyle's been catching plenty of breaks. He's been rolling lots of natural 20s, but
it's all
to find a lot run out.
It's not Kyle. It's the prosecution rolling not even rolling natural ones. They pick up the dice and they set it down at nat 1.
So I've asked this before as lawyers, can you guys show any evidence of racism? I think in the Kyle Rittenhouse trial, nothing that has been admitted into evidence. I know there's been a big to-do about the other video that catches Kyle's voice talking about how he wants to shoot people that are I don't know, stealing things from some kind of store or something like the night before, a few nights before. But none of that has come into trial. But in the Ahmaud Arbery case, there is evidence apparently that came in that that either one or more of the defendants used the N-word while they were trying to apprehend him. So I don't know if you guys know of any other evidence.
No,
I mean, it's going to be hard to make a racism argument in the Rittenhouse case.
Here's one off topic: Christmas music. Is it frowned upon to listen to it before Thanksgiving? I currently say no.
I frown upon listening to it any days other than Christmas Eve, Christmas Day, and then off it goes.
No, I agree. I dislike Christmas music. I like the lights. I like the presents. I like lots of things about Christmas, but the Christmas music, man, it's everywhere. It hurts me.
I think maybe
it makes me irrationally angry.
I think me being so last year, Mr. Bytes and I we moved like in November, so it felt, and then we didn't have any of our stuff for Christmas, so it just didn't feel like a normal like homey Christmas. Although we did have Holmes as a kitten, he was adorable. He was like this big. But this year we decided to start Christmas a little bit early. We've got some lights up in our place, and I've got like Christmas like jazz on YouTube streaming in the mornings, like coffee shop music. But that's just me this year. Maybe next year I'll feel differently about it. So let's see here. It takes 20 hours if you're trying different methods to produce a desired result, and not following AMP software's recommended forensic workflows. That may be responding to another super chat that we had earlier. I think Donut Operator did a better video breakdown than Kyle's defense team did. Keep up the great work, everyone. We'll be watching on your streams. Thank you. I know we're definitely having just a lot of, I mean, it feels bad saying this. We're having a lot of fun doing this because obviously it's a very serious case and Kyle's rights are a very serious matter. But I mean, the truth is like all of us getting together and talking about these subjects, like it's just a great time. No matter what case we're talking about, what controversy, it's always just a good time. It's just getting together with friends and talking about these cases, you know? If a juror has expertise in computers, could they argue against the video stills during deliberation? Absolutely. And this is exactly why you don't necessarily want anyone on the jury that has any sort of knowledge of the most important aspects of the case. So if there's a computer science major on the jury, that can end up putting some weight on which way they look at certain pieces of evidence, for sure. So that's why, like, there was one case that I remember when I was a law school intern. There was a case that involved an inmate in California that had sued the state of California for some sort of a dental procedure, and one of the jurors was like a nurse or something like that. And I remember that it was actually the defense, the state, that had put the nurse on that jury. And I remember like really wondering why, specifically for that reason. But I guess sometimes it can go one way or another. But typically, I would recommend not having someone on the jury that has any level of expertise. The entire case was Rosenbaum. Oh, sorry. Go ahead.
You can end up basically having a jury of one in that case. It's one reason why in this area where I am, lawyers are bounced. You cannot serve on a jury if you're a lawyer. And it's because they're worried that lawyer is going to have an overwhelming influence on the jury and possibly might correct the jury instructions. But you don't want to have it where there's one juror who's just so overwhelming to the other jurors that they go, oh, well, we'll just all listen to them.
Yeah, exactly. The entire case was Rosenbaum falling until last day, and then they threw the provocation Hail Mary, and the defense didn't stop it. Yeah, we'll see how it works out. Could ask for the drone's flight log and the manufacturer as well as pilot's qualifications. I mean, I don't know if they even know whose drone it was, right? Because didn't they just pull it from the internet? Oh, Nate's back.
And they stipulate the authenticity, which is just a great move too.
Yeah. Hey, Nate.
I like watch.
Oh, you're
football game. Like watch the football game. I know. Beer. My kids did homework with the kids, and I'm like, you guys are still on? Wow.
I know. We're still going strong. We're prepping for tomorrow, right?
Well, I think with Nate here, I'm going to take a leave because I'm a little bit tired and I might want to do some other stuff on myself now.
Sure.
So I think I'm gonna depart,
thanks for joining. So. Okay. It's good seeing you, Kurt. Yeah, Nate, you missed Nick. He was here earlier. He popped in when you left.
I watched for a little bit. I saw Nick in, and then I was like, okay. But then I was on my phone. My phone died, and I opened it back up, and it gave me it was showing you guys were still live. I was like, oh my god, you guys are still live.
Yeah. Oh, I wish I would. Dang it, this happened again. I wish that Kurt would have seen this one for the Ocean Mandate versus the Fifth Circuit.
Yeah, he seemed down. I think that escape thing probably got him a little down.
I think so. I hope he doesn't beat himself up.
I think he's taking it too. Kurt, if you're listening to this, you're taking the escape thing too rough, brother. It's okay. It's the word escape. Who cares? It's Georgia law. You're in Texas. Who cares what you know about Georgia law? Let it go, brother. Let it go.
Yeah, for sure. So, Nate, what are you drinking?
I got a Heineken.
Oh, nice.
Even though I do not support, and that was not endorsement of their products.
Hey, sometimes stuff just tastes good.
That's true, yeah. Well, it's just cheap and easy to get around here. So
that too.
Yeah,
those are the two big things.
Oh, did you guys see the Ben and Jerry's tweet about justice being dead or something like that because of racism? Because if Kyle had been black, the whole thing would have been different or something.
Yeah, you know what? It's funny because. Like when I see things like that, I understand Ben and Jerry's and all these places have good intentions because there is a history of that, but that is not this. And just to and I always think the nuance is dead argument. It's kind of the world that we live in because if you look at this trial has absolutely nothing to do with race. It happened to have the only issue with race that it happened at a Black Lives Matter protest for Jacob Blake, right? But that's really the limitation of this was race-based. All the people who were shot happened to be, the people who were shooting and shot were white. This happened just to be kind of a self-defense claim. So it's not like Kyle said the N-word or something where you can even make that assumption. So it's like, I understand why Ben and Jerry's want to be on the right side of history because you want to be on the right side of history. And the history of this country. But if you are responsible, you would look at each situation on its own and then determine if the facts and circumstances deem them to be like that. And that's what happened with the Ma'Khia Bryant situation. Remember, she's the young lady who the officer gets to the scene. Another woman is she's trying to stab somebody. She's literally in the downward immersion of stabbing someone with a knife. The officer shoots her, saves that woman's life. and the first and the only thing everybody saw was race. You know, black victim, white police officer. It must be wrong. Even while the tape was there for all to see. You know, LeBron James had to take down the tweet that he put up about it. So I understand people being sensitive about it, but that's still no excuse for not looking at the facts and determining each case individually whether it is justified to say that and whether it is not justified to say that. And my last point is, like, even with Ahmaud Arbery is a case where I can see now where race should be mentioned, right? They did use the N-word before they killed him and after they killed him, right? That seems to be a part of this story. Now, that's justified to say because that's what it was testified to. But I also think that if you really look at the underlying effects of why this happened, race plays less and less of a role. Even in the Ahmaud Arbery case, even though I think race did play a role, but not as a significant role as people are making it out today.
Yeah, no, I definitely agree.
The other thing I hate is that when we look at an argument like this, the argument is basically we would not be fair to a black person in this situation. And people go, okay, great. I like that you're pointing out an injustice, but the solution to that injustice is to treat the black person fairly, not to treat Rittenhouse unfairly.
Agreed. That's a very good point too.
Do we need to have this universe where we treat everybody in the worst possible way? You know, that's
the Soviet Union right there.
Like, I don't care who Rittenhouse is. He should be acquitted here because he's innocent.
Right. If there's a retrial, is there anything to stop people contacting Kyle and his family to convince him Richard sucks and he needs new counsel? If they're not looking to represent, is that soliciting? So attorneys definitely can't reach out to him for that purpose because he is represented by counsel. And I would imagine every single state in the United States has or every single bar, in every state has that rule of professional responsibility that if you know that somebody's represented by counsel, you cannot contact them directly unless you have the permission or the consent of the attorney. And for sure, I mean, obviously, I don't think Richards would give consent for anyone to poach his client from him.
Although you never know. He's agreed to some weird things in the trial so far. He might just be like, yeah, by consent.
Oh, that's fair. That's fair. I may or may not have hit some DMT right as Nick was doing his doggo motion. That was a deeper dive into Richards than I was expecting. Nice. Let's see here. Are we almost? We're getting close. Here's another one. Thank you. Okay. Fave LeBron rebuff. You cried when you got a cramp. Oh, I did see that. Yeah. Let's see. KRPTSD on a developing brain. I'm praying. Yeah, that's hard. I think it definitely looked like he had PTSD there. So, I mean, when he was on the stand. Oh, I think my earbuds finally died on me. That's how long the stream has been.
You gotta go. You gotta wire up now. You gotta wire.
I know.
I know. Do you have a delay on your? Because my Bluetooth. I have a delay. Like it's a slight delay. So
I didn't.
People are talking. I can't hear it.
I didn't notice it. But maybe probably not if it wasn't noticeable. But I can't believe that actually these were fully charged up too.
Well, you just crossed the 4-hour mark too, so I don't know how much, how long.
Yeah. I mean, I guess 4 hours is it. I guess.
Per charge.
Oh, wait a minute. Why is this happening? Oh, hang on. Let me fix my audio here.
Bluetooth is great especially when you do these long live streams, because I remember, when you're cabled up, you got to take off the headphones, then you kind of miss what's being said. You got to come back to the computer. Bluetooth, I walk around the house.
Billy exposed alert behind Bytes. It's rub time. Oh yeah, Indy was doing her draw me like one of your French dogs poses. She likes that one. Let's see. Or they could keep their mouths shut and sell ice cream. That goes for all these virtue signaling companies. Yeah, I mean, fair, but some companies also they want to feel like they stand for something, right? I mean, you could see, I could see. I mean, didn't the Black Rifle Coffee Company do something along those lines too with this case? I mean, weren't they helping Kyle out or something? I don't know. Maybe that's just
free speech is free speech. Ben and Jerry have the right to talk, and they can say whatever, and we can decide if we like them or not based on what they say. I don't have to agree with them to say, go ahead and talk. That's
true.
And I mean, I don't pick my ice cream based on the opinions of the people who make it. It's, how does it taste?
Jerry, right?
That is true. I pick it more on taste and price. So usually I don't go for Ben & Jerry's, mostly on the price point. Runkle, are you familiar with R.V. King, regarding the 2017 shooting of Yosef al-Hasnawi? It would be interesting to compare with the Rittenhouse trial.
I'd have to pull it up and do some digging on it. I'm vaguely familiar with it, but I'd have to actually read it. But it might actually make for a decent video. So,
alrighty.
I will pull it up.
I think this one might actually be the last. Oh, well, no, there's another one just popped up. It seems like these political. Yeah, it seems like these political trials are becoming more frequent. Are dirtbag prosecutors like Binger and Krause common? And if so, how can the general public fight back against their influence on our legal system? I mean, I guess, when it comes to voting for your DA, voting for, don't show your butt to the camera. What are you doing? Like when it comes to voting for the DA, voting for someone that isn't going to be bringing these kinds of political prosecutions that have no real merit. Right. And I don't know. Can you guys think of any other things?
See, this is the problem with the system that that's more of a critique of our system than a critique of the particular office, right? Because all prosecutors' offices that are elected officials are by nature political, right? Those are political positions. So they have bosses, and their bosses happen to be the public will. So if you notice in southern states where they elect judges, for instance, when it gets around, they've done a survey of their rulings. And what they did was they said, okay, well, these judges who are political judges, they have to go through the political process. How are their rulings, or do their rulings or the way they rule in criminal cases different based on when they were being, when election time came up? And they showed that when you started getting close to election time, sentences were harsher, judges were crueler, like they became harsher judges during that time, because the politics of the nature down in the South was, put them away, that type of thing. We want, law and order, that type of stuff. So judges, you didn't want to be the judge to say, not, have this guy who happened to do something bad, give him 5 years, you give him 10 years, right? Because you wanted to see hardcore judge. So they noticed that pattern. And there's really no way they can change that because of the political nature of the judgeships in the South. It's really nothing you can do. Judges are running, and if people want harsher sentences for criminals, they have to give that so they can keep their jobs. And when it comes to district attorneys, they kind of are in the same realm. So when you, like, for instance, in Atlanta, with the cop that shot Rayshard Brooks, literally the week before the shooting, that DA was in a news conference and said the words, literally, taser is a deadly weapon under Georgia law. Meaning, if you point a taser at a cop, you are pointing a deadly weapon, and that cop can respond with deadly physical force. Simple enough. Then a couple of cops, and that's when he was prosecuting police officers, right? And that was because he's in a very democratic city, police bad, police pointed tasers at some people, they got to go down. Then next thing you know, now a citizen pointed a taser at a police officer, and that police officer responded with deadly physical force, right? Just as the book. Now the taser is not really a deadly weapon, right? The taser, it's just a taser. It's not going to kill you. That's the nature of and he lost the election, but that was the nature of the politics. We understand that police bad, so we're going to hammer them. Black man shot by police for pointing a dangerous weapon at them. Maybe we don't really care about too much. That's the difference. And it's a shame, because I don't know how you would fix the system. Do you make them, do you make them not political animals? Do you give them lifetime appointments, like as they want the federal judiciary? Not for the prosecutors, but for the judges. It's almost impossible to fix. I think the political nature of state and local judges, and even state and local prosecutors, is just one in which, our system is kind of built on that. Maybe changing the voting public will be something you do, but it's going to be very hard to change just the political nature of the prosecutor's office. It's just how it is.
And things are different here. We don't have elected judges. We don't have elected prosecutors. And I kind of feel like things are better here. I've seen, when I talk to American lawyers, they tell me story after story after story of prosecutorial misconduct. Whereas here it's rare. There's, a couple of situations where I think the prosecution has acted badly, but I don't have a lot of examples of that. And what I have a lot more is examples here of prosecutors behaving well. Situations where I got a call from a Crown. I was set up for a trial, and he calls me up and says, "Hey, don't bother prepping this anymore. I've heard some new evidence. I'm not going to be able to get it to you before the trial, but I've heard it exists, and I'm not confident in this prosecution anymore." I had a trial where the trial ends and the judge says, "Well, I'm inclined to convict," and the prosecutor just said, I'm killing this file right now because I don't think a conviction should happen." Notwithstanding the fact that the judge was making it clear the judge thought a conviction should happen. Prosecutor's like, "No, I don't believe it. I don't think that we're past beyond a reasonable doubt here. I have serious concerns about factual innocence. I'm done." And the judge was actually upset, was annoyed with the prosecutor, who had to stand their ground and said, "Hey, sorry, I do think you get a better system with that. And I kind of am afraid of a system where you might be charged with a crime and convicted, not because you did it, but because the popular wisdom is that you should be convicted." That's terrifying to me.
Yeah.
It should be terrifying to Rittenhouse say.
Yeah.
But I don't want to make it seem like all their decisions are political in nature.
Oh, yeah.
You know what I'm saying? But when something like this, again, and I'll even take the Rittenhouse case, this Democratic prosecutor's office has to answer to their Democratic constituents. Now, do you think that prosecutor can do one or two things? It can prosecute the case that it knows is a loser, lose the case, justice is still served, and then blame it on the court system. Hey, look, the jury didn't convict the kid. What do you want me to do? I did everything I could do. So it's kind of that kicking the can down the road. And I think that's what happened in this prosecutor's office. The lead prosecutor generally takes all the high profile cases. You got probably the case of the century, right? Up until now, right? The case of the century, you got the prosecutor's not going to take it. He's going to give it to an ADA. Okay, so he gives it to this ADA and they prosecute it. And I don't think really any reasonable person would have seen this case, really would have thought they could win it. But that person right now is assuring that I'm going to get these Democratic votes. The mayor's the Democrat, representatives, everybody who served that community is Democrats. And everybody who serves that community, they took a survey and like 70% of them believe Kyle was already guilty. They're not voting for Trump there. You know what I'm saying? And that's what I'm saying in that situation. The politics of that small community, I think, dictated what the decisions that this prosecutor made. And it's also going to dictate the outcome of this case, because don't forget, if the trends are correct, that means 70% of those people sitting in that jury box already naturally believed, if you believe the polling, that Rittenhouse is likely guilty. So those minds have to be changed. So is the evidence strong enough to change those minds? And remember, you're talking about changing them all. You're not about changing one or two. I don't know. We'll find out next week.
Yeah. Well, here's another question. This is probably more for you than anyone, Nate. If the women's soccer team won the 2020 gold medal, would have prevented all riots in Kenosha and legal mindset from living in a bathroom.
My poor boy, legal mindset.
Hey, don't be so sorry for him. I'm convinced he's going to have merch on it. In fact, I'm encouraging him to do it.
If he doesn't get a toilet seat cover based on that, he's sleeping on the game.
I know. I agree. I totally agree. If Hernandez brought up the pedo charge, would that have opened the door for Kyle's history? Well, I don't see how Hernandez would have been able to bring that up, because it's not really relevant to anything that he saw, heard, or witnessed at the time of the incident. So it's like the only way that he would know about it is by investigating it after the fact. So I don't see how that would even come in the first place. So
that's true. I don't know how you get. Even if Hernandez was to bring it up, that would be an objection. Like, why is he even bringing it up? Why is it relevant to his testimony?
And the jury would be instructed to disregard if he got a statement out on that. I mean, but then the cat would be out of the bag on that one, though. Even still, like I don't know how you can unring that bell when the jury has heard something like that and they're like, wait, I'm not supposed to be hearing about something like that.
But that may cause a mistrial, and that would hurt Kyle at that particular point in time.
True.
Yeah. And it's kind of an unsolicited response. Like, what would be the question that could possibly get that response? Oh, he was what? What would the lawyer ask to get that response?
Yeah.
Unless he's just going to make it like a cited utterance up there on the stand.
Yeah. I didn't know that Black Rifle Coffee went against Kyle. Clearly, I was not paying that much attention.
Yeah.
Do you guys think backing legislators willing to pass more laws regulating prosecutors and judges is a worthwhile endeavor?
They've got the laws there. They're just not enforcing them against the prosecutors, when they... Like, when you hear about cases where there's a wrongful conviction because the prosecutors sat on evidence, or a wrongful conviction because the prosecutors, coached witnesses or whatever else, you look at it and they're like, oh, and now we're interviewing this guy. And what's his tagline? Still working at the prosecutor's office, possibly as the chief prosecutor now.
Yeah.
There's no consequences for it.
Yeah.
So why do we think more laws are going to help when we're not enforcing the ones we've got?
Fair.
I don't know. Well, I'll disagree with that for two reasons. Number one, Duke LaCrosse, right? That prosecutor was disbarred for doing the same exact thing, right? Mm-hmm. Duke LaCrosse. So prosecutors, there is a penalty if you do go too far. But I think how much is too far? It's the standard.
But that still falls within enforcing laws that already exist, because prosecutors actually have extra professional responsibility requirements than even normal attorneys do, because of the fact that they have the weight of the state behind them.
Well, for an ethics violation, the prosecutor is supposed to seek justice, not convictions. So if it's just to dismiss the charges, you're supposed to dismiss them. If you don't, that's an ethics violation. You could be found in violation of ethics charge. So I do agree it's enforcing existing laws, but I think the interpretation, the way existing laws play now, you have the scarce resource argument that prosecutors, have scarce resources, so they gotta have to pick and choose what to prosecute. They have prosecutorial discretion, for instance, and in this case, the standard to bring charges is, do you have probable cause? Now, those things that was mentioned earlier about coaching witnesses and stuff, those are just unethical for any attorney to do, for coach witnesses and so forth and so forth. But I'm talking about specifically for prosecutors. I think, unless you do something that's just blatantly unethical, the standard is that you kind of pick and choose your cases. And here, was there probable cause to make an arrest? 2 people dead, 1 person injured, 17 with a gun. The story you get some people saying that he was chasing them, some people saying that he wasn't. You have tapes that seem to suggest something. Probable cause is a low bar. Yeah, you can bring a case here and not be held in, not violate any law. But I think, all of us as attorneys would say, should you have brought this case based on what you really see? Could any reasonable prosecutor think they can win? And I think the response for this prosecutor would be, I didn't bring it to win. I brought it for justice.
Yeah.
And justice means that, whatever that means.
Yeah. Runkle, can you talk about the right to silence in Canada versus the U.S.?
I think I've mentioned a couple of it, and I'm not an American lawyer, but there was some discussion from the panel about bringing Rittenhouse up for a limited direct so that they could, ham in the cross. You can't do that here in Canada. If you get up on the stand, you've opened the door. Your choice is testify or don't testify, and they can't compel you to testify. But once you get up there, you're fair game. So that's one big difference. The other is in terms of how we deal with secondary witnesses. Like, let's say you're a drug dealer and you happen to, you've got a kilo of heroin in your backpack and you happen to witness a murder. And you can get called to testify and they can say, what were you doing there? And your answer might be, well, I was actually transporting my kilo of heroin across town, because, assuming you're being honest, that's not considered a right to your right to sort of not assist in the prosecution here in Canada, because there's actually a limit to the use of that evidence. If they then want to charge you for having that, had a kilo of heroin, they wouldn't be able to bring up those statements in your trial. There's some other situations where statements can be compelled from you here in Canada, but where they can't be then used against you in a criminal trial. So, for example, some situations for, like, if you've been in a car accident, you may have to provide a report of the accident, but they may not be able to use that against you to charge you criminally. And some of this gets real complicated because our rights tend to, as a general category, be less absolutist. There's actually a provision that says if there is a violation of your rights, what sort of remedy should result, which can often be nothing. So we can have situations where the police can search you improperly, and the remedy might be, okay, the evidence still goes in. It's this is something that can be shocking to U.S. lawyers.
A quick question. What about, like, fruit of the poisonous tree? Let's say, for instance, I'm in that first trial and I say, yeah, I transported the coke on a train or whatever.
Yeah.
Then they say, well, I can't use that statement. But what about, let's say, can they go to now the train people and say, okay, how often does this guy buy tickets, so forth, and use the information that I got to get circumstantial evidence against me?
That one I'd have to look into, because there are restrictions, but it gets complicated as to how that breaks down. It's not an absolute protection, and they could still investigate. So you could, for instance, see somebody who got up and said, hey, I saw this because I was in the process of disposing of the body while I was murdering my wife. And, that's how I happened to be there to see this. And they could then say, well, we're starting a Mr. Big investigation against that person, which is another tactic that is, from my understanding, forbidden in the States, but allowable here. And kind of a horrifying tactic if you get right into it. Just how... That's for another video, really. That's for another topic. But there's all sorts of things that are forbidden in the States that are allowed here. And conversely, there's some stuff that is forbidden here that's allowed in the States. But, another big example is your right to an attorney. In the US, it'll be your lawyer walks into the room, sits down, and says he's got nothing else he wants to say. Here in Canada, unless the accused is a young person, under 18, what I get to do is the guy calls me up on the phone and I get to tell him, okay, you have to keep your mouth shut. It is vitally important that you keep your mouth shut. This next couple of hours is going to determine the rest of your future. And then I have to hang up the phone with a good luck and hope he does it. And he doesn't get to have me sitting there. If I show up at the police station, say, I want to sit in on this interview, they can park me in the lobby and say, we'll call you when we're done. And I don't get to walk in there. So there's a big distinction.
What happens if they quip a news clip, such as he died like he lived trying to touch a minor? That is not going to fly. That's definitely not going to fly for sure. Black rifle narrative is wrong. It was from the right after the incident before any facts were known. Their stance was not profiting from tragedy. I changed my pants today. Congratulations. I'm proud of you. We're definitely starting to get some interesting super chats at this point, and I think we're going to be wrapping it up soon.
I think that's the reason why, because you said you want to wrap it up, so they're throwing you super chats to force us to stay, which is great.
I know. Which, I mean, thank you for throwing money at us, but we gotta get going. I'm gonna just take a look at some of these. Okay, all right, and that's it. No more super chats. If anybody does any more, I'm not showing them. Okay. Well, that should be about it. I mean, we have probably cooked everything through and through, right? After like almost 4.5 hours here. This is the longest stream I've ever done on this channel, and probably the most super chats I've ever gotten. But thank you, Nate, for coming. Thank you, Ian, for being here. You definitely stuck it out for the entire time. And thanks to Good Logic for being here, on civil law, Nick Ricada, So this has been a really great stream, and I'm really glad that we had a chance to kind of go over everything in the Kyle Rittenhouse trial and the Ahmaud Arbery trial. So we're going to see how things are going to go. Tomorrow, I think probably most, if not all of us, are going to be on Rekida's channel. Nate, come on. All right, that's the last one. The absolute, no. Come on, guys. And otherwise, be sure to like the video if you enjoyed this, and subscribe to the channel if you haven't already. If you're chatting, you are subscribed. You've been at least for 10 minutes, because I had to put that in because of all the spam bots that we were getting at one point. Otherwise, check out the merch if you guys are interested in supporting. Otherwise, you can become a member. You become a member on the YouTube channel. You can also add more super chats. Otherwise, you can also support us on Locals and on Patreon. And with that, we're done. No more.
I also just want to say I've been watching Nate. I've been catching up on Nate's commentary because a lot of it's been happening while I've been on a different live stream. And watch his coverage of the Arbery trial. It's fantastic. Yes. I've been really enjoying it.
Thank you.
Agree. Yeah. And be sure to subscribe to everyone that was on here if you're not already, of course. All right, last one. Last one.
And now she's gonna click them.
No, we're done. We're ending. Okay, bye.